The I'll start again. The meeting's being recorded. All right. Good morning, everybody. Welcome to our second Rules Advisory Committee meeting for the Water Rights Rulemaking. As a reminder, my name is Katie Ratcliffe. I'm the Water Rights Services Division Administrator, and our co-sponsor for the rulemaking is Raquel Rancier, Deputy Director of Strategy and Administration. Now, I think most folks know the logistics in the room, but I'll go over it real quick. Down the left is restrooms and then a stairwell if you needed to make an emergency exit. Off to your right is the elevators, but there's also a bottle station or a water fountain and a break room. And we've also got some light refreshments in the corner, so feel free to help yourselves. I'll turn it over to Laura Hart, our rules coordinator.
Maybe. There we go. Okay, so here's our agenda. Just quickly, we've got some housekeeping items at the beginning of the meeting here. And I'm gonna hand it back over to Katie and Raquel, who are gonna tag team on going through the rules for today. And then we're gonna wrap up with public comment and next steps. With respect to, well, a couple of things. So first, we did update the rule summaries for last week's RAC meeting, as well as the RAC meeting today. And for folks in the room, there are handouts with those compilations. I will be uploading the revised cover sheets attached to the draft rules on the website as well, for those that just want it all together.
Laura, can you tell them why we updated those sheets?
Yeah, we updated, so that was in response to comments we got from RAC members who wanted sort of general tags as to whether the rule changes were due to legislative implementation or process improvements, or if there was some other need that we were addressing through the changes. So hopefully that will help orient you as you go through the draft rule packets. And then as far as last week's meeting summary itself, we're still working on that. We've got sort of the general conversations captured, but we're going through on the very specific rule input that we received from the RAC, and we want to make sure we're tracking the comment and tracking our follow-up to those comments. I'm hoping we can get those to you next week, but I don't want to promise that. That is certainly our goal. The meeting recording itself is already uploaded to the website, so if you do want to go back and kind of review the conversations, that opportunity is there. But we want to give you that summary too for folks that don't have time to, you know, sit through a 3-hour meeting to get the high points. Let's see, I do have a couple slides here. So in terms of the timeline for our rulemaking, I think last week we indicated we were looking at either February or March adoption with the commission. We've decided we're going to do the March adoption, which will allow us to notice the rules the beginning of January, so we can avoid the holidays for the public comment period. And hopefully that way we can, you know, still meet that April 1st implementation date. I will be posting this PowerPoint online as well, so don't have to write everything down, but yeah, it's an important update. The other, let's see, yeah, this is the other important update to give you all. So because Division 380 and Division 77, those are kind of beasts in terms of they're both like 60 to 65 pages. We're still working through those, doing our internal reviews, doing our quality control on those. So in order to keep moving and stay on schedule, we moved Division 17 up in the timeline. So we were tackling that later. I think we had it scheduled for our last meeting. Now it's going to be during the 4th meeting. And those draft rules are we've already sent them to you, and they're printed out in the back there as well. And then in response to observations among RAC members and ourselves, we realized we probably will need to add some meeting dates in November. So if you got to the bottom of that email I sent you the other day, there was a poll at the bottom for you to complete. I think a couple of you have done that already, so thank you for that. I'd like to request you do the same thing we did last time. You all did a great job. Provide all meeting dates and times that you could be available either in person or virtually in that poll. And I think we probably put 2 holds, and hopefully we won't need both of them. Maybe we won't need neither. We won't need either. We'll know more in October, I think, but we want to just get things on the calendar. I did avoid the legislative days in November, so hopefully that won't be a problem for most folks. And I'd like you to get that back to me by October 1st. Hopefully it'll be easy to remember because that's the same day we asked for the input on the first RAC meeting materials. So you just remember October 1st, you got 2 things to make sure you get done. That's the poll and any written input you want to provide on the materials we presented last week. I think I'll pause there and ask if there's any questions about those housekeeping items before we go to rule discussion.
Sorry, I'm late. Was it noted that the dates didn't line up on the poll, on the online survey, the Thursday, November, or?
Oh, did I have the wrong day of the
It was
week
like
on a
Thursday,
date?
Friday was like,
I'll double
it
check
was either
that.
Thursday or Friday, it was like
Was off.
switched. The
Okay.
date, the date and the day didn't line up,
Okay,
but everything else seemed to be.
the numbers are right, but I'll go back and fix the days of the week, so apologize for that. Thank you for noting that. Probably won't be the last time I do that. It's easier to just put the date and not worry about the day of the week. Are there any other questions or comments? Nope. Okay. I will turn it over to Katie, and we have that table. Do you want the table first, or you want to?
Yeah, let's put that up. Thank you.
Before we get started, I just want to do just a point of order here. So I have that Anton, Jen, James, and Jeff are not here today from the RAC membership. I'm wondering if anybody here is attending as their proxy today.
James just raised his hand, so he's here.
Oh, James, sorry. This is why we're doing this. Good to see you.
All good, thank you.
Can you hear me? This is Kate, and I'm about to get on the computer, but right now I'm on the phone from the DRC.
Okay.
And
Kate, thank you.
this is Marika Sitz from Jordan Ramus, and I'm sitting in for Jeff Stone again today.
Okay, that's what I thought I remembered, but thank you. So everyone else that I have that is here, Richard, Brian, Jeff Shaw, Ken Yates, Michaela, and Ryan Gleason and Brandon Self, I think are all here attending as members of the public. Is that correct? Oh, apparently, welcome, Brandon. Apparently you're one of our own staff. So
He's new.
Okay,
Yes, sorry, trying to get the microphone. I'm a water rights caseworker, and I just joined this month, so I'm excited to hear all the new things coming out of it. So thank you.
okay, and thank you. Now we can get started.
Okay, all right, thank you. So I'll be discussing Division 305 along with our subject matter expert, Jerry Clark. He's our program analyst in the certificates program and one of our mapping experts. Division 305 is a proposed new division, and it's intended to house standardized map criteria. So the idea is to create standardized criteria for maps for many of our water right transactions. And it came about through discussions with some of the folks that are in the RAC, through discussions at our CWE trainings, through seeing some of the challenges we were having with quickly getting maps that met our needs, right? Where we didn't have enough information to complete our evaluation, and we needed to send maps back, or we needed to continue to ask for more information. So in the vein of addressing some of the concerns that we heard, increasing consistency and reducing processing timelines, as well as making sure that there's sufficient information on there for folks to understand the proposal. We've proposed Division 305, and it, in some cases, removes some unnecessary requirements, some that we thought maybe there could be a little more flexibility for municipalities based on, in practice, how we were handling those at intake. And we wanted to add clarity to our requirements where we thought some of the language was a bit confusing for folks. Our draft Division 305 lists off the rule divisions that it pertains to, but we've also got this slide in the handout on the well, actually, it's just in the PowerPoint. That lists off the divisions where you're going to see a reference to Division 305. I'll note that Division 305 also applies to alternate reservoir applications. Now, those are only at statute at 537 or as 537-409. There are no corresponding rules for alt res statutes except a reference in statute to the commission's mapping standards. And so you'll see reference in Division 305 to not only the divisions shown on the slide, but also ORS 537-409 for the alt res process, alternate reservoir. The way we've structured the rules is that some of our rules simply refer to the Division 305 mapping requirements because at this time, we think that Division 305 covers the needs for that particular process. Other rules also refer to not just 305, but contain supplemental mapping requirements. And a lot of those already exist in our rules. So we've taken out some of the language that we saw in common across our rules and put it in 305. And then left some of the supplemental mapping requirements that already applied or made some adjustments if we thought that any were needed. So if it looks like something's been taken out, it may have just moved to 305 because it's a standard in common across these different divisions. So at our last meeting, we talked about how do these divisions interface? So we can use Division 14 as an example. We have section 0170, and that is for maps that are required to be submitted as part of a claim of beneficial use. And that says maps submitted as part of a claim of beneficial use shall meet the standards in OAR Chapter 690, Division 305. In addition, the map shall meet the following criteria, and then it lists it out. I'll give another example where we have supplemental map criteria based on the nuances of that particular water rate transaction process where we need a bit more information than the information we need in common across all processes. So for example, Division 18, allocation of conserved water. It requires that the map both meet Division 305 requirements and also that it provide supplemental information on the details of the facilities and areas affected by the conservation measures. So not every water rate application pertains to conservation measures. Allocation of conserved water, it's in the title, it clearly does. Therefore, we need to see information about where those conserved measures would be. So we also heard last week that the RAC was interested in learning more about perhaps a crosswalk between 305 and the other divisions. This table is a start. There may be a desire for more information. So what we're doing is we're pulling together just a kind of easy reference where we've got all the map rule language for each rule division put into a table. We don't have that available for you today because part of what we're doing as we're going through it is we're seeing, are there any further opportunities for us to create additional clarity and reduce further redundancy? We're taking in comments already from RAC members, from other folks in WRD, from our sister agencies. And so we're doing that look at the same time. And we'll be providing our input back to the RAC after we've heard from you in your comments on 305, so that we can provide you one package that's in response to everybody's input. And we'll provide you the crosswalk table at that time as well. Okay, so opening it up for questions. Or comments, yes, and I'm reminded that we've got the ability to turn, like April's demonstrating, your name tag up like this in the room so that we can see that you'd like to comment. All right, April, please go ahead.
So thank you for that summary and update. I do appreciate that. Would ask in additional table walk kind of references or at least some description going forward. It would be helpful to indicate where, like in this instance, if I'm tracking correctly, the 305 here is going to be a new rule section. And in some instances, there's going to be other rule changes where 305 will be, that other references will be removed and 305 will apply instead. Whereas there's going to be other sections where this will be in addition to what's already in an existing rule. You know what I'm saying? Something that kind of indicates we're removing pieces here in lieu of here, or this is going to be just in addition. Does that kind of make sense? Just something that gives a little marker of additions, deletions, substitutions maybe, or something along those lines. It might make it a little easier for not only us, but others to track how this is going to fit as far as it, again, being an addition, deletion, substitution. There's a lot of crosswalks that are gonna happen between
Yeah.
the rules.
So, thank you for that, April, and I think that's why we've got this table that started, right? And it's actually almost completed, but when we were looking at it, we're like, we wanna actually, now that we're looking at it all in one table, we wanna come back and make sure that we've done a little bit more due diligence on some of the areas where we may see an opportunity to put into 305, again, for that streamlining purpose. So I think for this group, when you look at the table, because we've taken the language, you'll see like the entire rule is deleted, for example, on 310, except for saying 305 applies, right? And so I think it will become pretty clear from the table just by a quick look down of like, oh, this one has additional requirements because it says division 305 applies, and then there's these two other things to it. So I kind of think we're already on that track with the table that we have. So we'll work on getting that out to you all as soon as possible.
Thank you.
We have Austin. Go ahead, Austin.
Good morning. Thanks for providing this table. I think it gives a lot of clarity to the linking other divisions. I have a few comments. My first comment is related to the scale section, specifically 2A. It says the map shall be drawn to a standard even scale of not less than 1 inch equals 1,320 feet. And furthermore, it says another scale may be granted if by waiver. So I'm curious if the intent of this, if there's a scale that's larger than 1 inch equals 1,320 feet, do those scales also require approval, advanced approval to be used in mapping? And the specific scale I'm referencing here that is most commonly used with smaller water rights is 1 inch equals 400 feet.
Turning over to Jerry.
Yeah, so the way that we had intended to write that is that we say the map shall be drawn to a standard even scale of not less than. And so what we're trying to imply there is that the scale needs to be an even scale. So 1 inch 100, 1 inch 200, 1 inch 400, 800, those would be acceptable scales under this. But if someone wanted to use some other scale that isn't standard even, an even scale, or if it was going to be a scale, how do we say that, less than 1 inch 1320, that they would have to request a waiver on it. They would have to get prior approval.
Right. I do have some further questions if I could field those now.
Go ahead. Thank you.
Great. So under the features section, under subsection G, so it lists the township range section quarter tax lot requirements for the map. Furthermore, it lists the additional requirements for municipal maps. specifically that they don't need to identify tax lots, DLCs, or government lots. I'm curious if the inclusion of donation land claims and government lots should be included in that original statement right beside G, as in township, range, section, quarter, donation land claims and government lots and tax lots.
Taking a look, just a second, Austin.
Yeah, I'm,
So I think we're gonna take that, Austin, and we'll get back to you. Jerry may have an answer in 5 minutes, but these are really great detailed comments, and sometimes we need a little more time to think through them. So I've got that note, that question noted.
Perfect.
Yeah, that's great though, thank you.
You have a couple more additional, they might be more detailed in nature, so I understand if we can't figure this out right now, but so under subsection or under 3, under the features, subsection I, subsection B, it lists, I'll kind of read it off, for places of use that are limited to a point, such as a stock watering tank. The location may be identified by latitude and longitude established by a GPS. I'm wondering if we should also include the distance or bearing from a recognized public land survey corner, similar to how PODs and POAs are can be described on maps.
Okay, we'll take a look at that, thank you.
Okay, great. My last comment is the very last subsection on this division K. Any other information the department requests and considers necessary to evaluate the water rate transaction. It's in my opinion, this is quite vague, and I'm wondering if there should be a more specific interest defined here, such as information regarding the subject water rate of the water rate transaction or something along those lines. The way it reads to me is there's really no limit on what information the department can request, and I think it should be more constrained to the water rate transaction itself.
So Austin, do you have specific language either now or that you could send us in writing? Because I do see the language says necessary to evaluate the water rate transaction. So it is specific to the water rate transaction.
Yeah, I think I could submit something in written comment.
Okay, thank you.
Thanks.
It looks like we have Jeremy Austin. Jeremy, please go ahead.
Thank you. I had a question just related to section 3 features as well, subsection generally applicable to subsection D. I was wondering if that requirement is to any ownership of infrastructure. For example, think of a scenario where there might be a district-owned infrastructure versus privately owned infrastructure, and what the requirements are being applied to.
So Jeremy, could you help us see exactly where you're looking? It sounds like we're under 3 and then
3D, general location of main canals, ditches, flumes, pipelines, pumps, or other water delivery features.
okay, great. And then I'm sorry, would you repeat the question related to sub D?
Yes. Is that requirement for mapping those features regardless of infrastructure ownership? It wasn't clear to me.
I would say yes, anything that's part of the system that would take water from the point of diversion or the point of appropriation out to the place of use is what we're looking for.
Thanks for that.
Regardless of the ownership.
Great, thanks.
Thank you, Jeremy. Okay, Christopher Hall, please go ahead.
Good morning. Can you hear me all right?
Yes, thank you.
Great, thanks. So I sent some comments to OWRD just on Monday, just encapsulating what I think is like the elephant in the room. It's kind of actually hard to see the screen because it's in the way at the moment. But really, it's the idea that in the 21st century, we're going to codify a new rule that is going to strap us into the ambiguity of mapping standards from the mid 20th century. And this will actually be standards that'll be going forward, I don't know for how many decades or however often the rules get revised. And so I'm going to share those comments here because I think it'll be the most efficient way. I just want to note that Katie mentioned that these rules came from earlier discussions with some folks on this RAC and some CWREs. So obviously there's a place from where these rules actually started that wasn't just OWRD. And it is pretty obvious that these codify archaic and imprecise practices. In the new proposed rule, Division 305, OWRD is designing for a 20th century workflow. This approach is outdated and it's likely unjustifiable from a perspective of the broader public. While there is a long history of strategic ambiguity around the location of PODs, POAs, POUs, and related infrastructure, that history does not justify embedding imprecision into the new rules that are now going forward. In virtually every other sector, mapping has moved into the 21st century, relying on digital tools to provide accuracy, efficiency, and transparency. OWRD should do the same. By drafting the Division 305 as is in this year to ensconce 20th century location standards throughout multiple rules, OWRD is not making a science-based choice, but a deliberate policy decision to codify these archaic and imprecise practices. And there's a few ways, I've got 4 of them, that the Division 305 rules maintain location ambiguity. The first, number 1, is requiring paper maps at a scale of 1 inch to 1,320 feet, which is very imprecise. This imprecision is a legacy of the USGS quadrangle mapping, but is no longer a factor in 2025. GIS maps can be viewed and printed at any scale, and other electronic means of mapping using GPS are readily available and easier to use than a drafting board with those old-fashioned drafting machines and parallel straight edges, which I have used. Who would insist on a 20th century legacy set of tools and the imprecision of a 4-inch section drawn on a letter-sized piece of paper? The second is requiring an electronic form to conform with paper standards is a reversal of the past 30 years of technological advancements. Any paper map should conform to the electronic maps simply as a printout. And printing out maps, unless you're walking around on site, such as staff on site, seems to be, also kind of archaic. Referring to the TRS, quarters, the public land survey corners, and so forth, for locations, and also to the general location of infrastructure with no standard for what that means is also, it also is really very ambiguous. Retaining the PLSS as the primary requirement standard maintains the ambiguous cadastral descriptions of the 20th century rather than the precise geospatial data that we can work with today. There's no reason that geospatial data shouldn't be required, and that if OWRD wanted to retain a backwards compatibility with old maps, then maybe requiring PLS standards additional to electronic mapping would solve that problem. And maybe perhaps Division 305 should require OWRD to bring any remaining PLSS paper maps into the digital age. And I understand that staffing time may not permit that. And lastly, making the latitude and longitude only optional in a couple sections seems dancing around what really is an issue that should be primary and put forward as a major 21st century advancement. Geotagging should be required across the board. Any CWRE, or for that matter, even a teenager with a smartphone, can generate longitude coordinates within seconds, whether they're on site, with their phone, GIS software, or even using Google Earth. And so I'd just like to restate that drafting this rule to ensconce 20th century location standards throughout multiple rules across the board with a lot of crosswalking. It's not a science-based choice. It is a deliberate policy decision. And I think codifying these archaic and precise practices is really a non-starter in this day and age. And I thank you for your patience and your time to share these thoughts.
Thank you very much, Christopher. I really appreciate you sending those comments in advance too, so we could give that, start to give that some thought. And so you make a variety of points, and we're gonna be looking into those, including whether or not we should require geospatial data in addition to the requirements that we have in 305. It's listed as optional in 305, but you know, a question of if it would assist water masters, groundwater review, public, us, with our review if we had that data. But I did want to just take 2 minutes, Jared, if I could turn it over to you to talk about why the public land survey system is still something that is kind of the basis for the maps.
Sure. So one of the key reasons that the PLS is kind of one of the main things we still use is because when we are creating a water right, we are creating a property right. And deeds and legal descriptions are based on that public land survey system. And so that's kind of why we are kind of, that's why we're there. In fact, early history of the department, water rights actually were issued with legal descriptions written on the document. So we're really tied to that PLS system.
So I do have a question then, if I may, co-chair here. So, you know, I think that, Chris, you make some good points because we are interested in modernization. I think the agency is also interested in making it so that, water masters, groundwater staff, folks that are well drillers, well construction staff, dam safety staff, all of our staff that are, you know, responsible for going out into the field and locating the infrastructure that's associated with water rights. We do have an interest in making that easy. And so certainly from that standpoint, we have an interest in to your point, having GPS data points, right? Because that does make that, if you've ever tried to find a well in the middle of a, you know, 40-acre field, it's not that easy if you don't have more precise information. That said, we also have this background here of establishing a property right. So I would ask, so I want to be clear that, you know, I hear your comments on it being a policy choice and intentionally trying to be ambiguous. I assure you that's not the case here. So what I'm looking for from the RAC is for suggestions, because we are trying to be efficient. We are trying to be sensitive to how much information we require. At the same time, in an ideal world, we would have the information, I think, that is necessary from a property rights standpoint, while also having information necessary for our folks that go into the field to be able to locate this infrastructure appropriately. That may mean, though, 2 things that have to be submitted. So I would ask this group to help us on this front and weigh in on how can we make this efficient for everyone and also accurate. So I'll leave that for this group. I see April has a comment, and then I see Chris has a comment, and then I know that I'm not supposed to be facilitating, so I'm gonna give it back to Katie.
Thank you, Raquel. April, please go ahead.
All right, I will try and be succinct because I think we got a lot of stuff to go through. So I think for just my own brain as well as other folks participating or watching, generally speaking, we can only implement what the statute allows. And I think that's one of the many challenges we have in trying to make things more efficient is the balance between working within the existing statutes, implementing the changes that were in the 2 bills, and at the same time trying to, you know, to me, it's reducing redundancies, making things more clear wherever we can. But when we get into making changes, and I think that's you were very subtle about it, Jerry, but there's a lot of issues, and I think folks around the table know that when we're talking about property rights and things that can alter the underpinning of a water right, we need to be really careful. And that's just a general statement. So in regards to 305, I'll look at this more closely and get you guys some specific feedback, but going off your guys' description, this is an optional thing. You guys could choose not to do it. If we push back and said, nope, we don't want to do it. My understanding is the result of that would be, we're left with the existing mishmash of mapping requirements through the different statutes and rules instead of it being in a perhaps more succinct fashion. Can there be some changes? Yes. One of the challenges that we've had is, yes, there's a desire to go to more electronic methods and using GIS, but we're trying to take something that is centuries old and move that into the new age. It's not going to be an overnight thing. And I think as just based on what I know of the folks I work with, we're not there yet to be able to make everything in GIS type layers and GPS. But I think trying to work within the construct of making things easier, but not changing the underlying policy. And if we want to change the policy, that's what new legislation can be for. But I just think we need to be a little careful about how we approach it. And at least with this one being more of an optional thing, I think there's some ways to make it more standardized, but if there is pushback largely from the RAC, then in the interest of us focusing on the parts that we need to do, maybe this is something we don't do. That's not my opinion. I'm just putting that out there, just in getting my mindset back in a RAC construct where us as stakeholders need to give feedback and help the department make these rules as best as possible before they put them out for public comment, or they're going to get a lot more feedback.
Very much, April. So we'll just have a few more minutes on this topic. Christopher, please go ahead.
Yeah, thanks again. You know, it's almost as if it sounded like the response was the inclusion of electronic 21st century technology would be mutually exclusive. The reason why I submitted my comments in advance was because I know they were a little bit dense. I will resubmit them with a little bit more detail, but I very clearly stated that there's, quote, no reason that geospatial data should not be required. And if OWRD wanted to retain backwards compatibility with old maps, then requiring PLSS standards additional to electronic mapping would solve that problem. And since that's been the paradigm going on for decades, I don't really see how that would be a problem. So I think this question about, you know, private property concerns is a non-starter. And I appreciate you, however, bringing that up because it helps me reinforce this point. Secondly, I got a sense that if we were to push for bringing these rules into, or this rule into the 21st century, then there would be a lot of opposition to it. And then we would just throw in the towel on all of Division 305. And I think that's just, I think that that's just not the way to go. I think Division 305 in its ideology and the idea of having it is brilliant. You should have like one area where mapping is standardized that everyone else can point to. And it just should simply be standardized for the 21st century and not the mid 20th century. And that's really what my standing comments are. Thank you so much.
Thank you very much.
Quick question. Chris just alluded to it, submitting comments about any of these divisions. Are those possible to be shared with the rest of the RAC members?
Yeah, that's our plan, is to compile, you know, after we get all the written comments, we'll put them together and distribute them.
Perfect, thank you.
So I do think the agency would like to move forward with some version of Division 305. You know, April is giving us a backstop here, so thank you on that front. So I don't think it was, I don't think there is any consensus that 305 should go away. And as a reminder, this is not a consensus process. So the agency though does have an interest in some standardization here. As a reminder, some of this is about us being more efficient, right? We've heard quite a bit we have a letter from the governor following session, and we also know that, the legislature has been very interested in us being more efficient. So I think the question that I'm hearing is whether there should be, both items that we need for the property right component and items that we need to modernize into the future. So I think that's a question that would be helpful to hear from the RAC on. And it may very well be that it would be helpful, Chris, if your comments, I don't recall if they include this. Sorry, we've got a lot coming at us. And quite honestly, Jerry's been the one that's been charged with doing a deeper dive on this one than me. And so I think it would be helpful if your comments don't already include this to identify the both and approach that might be helpful of where you would suggest us requiring items that would bring us into what century are we in these days? Trying to move in. I never remember these kinds of things, as well as, of course, the old 19th century water rates, that we, system that we also have to make sure that we're complying with. Because, to that point, we do need to make sure that we are meeting, the requirements that we have to, establish, the property rights. So, if you have thoughts on that, would love to hear them from anybody in this group, not right now. Because I would like us to move on to our next division. But if you want to submit those over to us, we'll take a look at it in more detail. Because that is the position the agency is in on everything, right? We have this old system. Some of it predates, was established prior to statehood. And we are still living in that system. And everybody wants us to be in a system where I pick up my cell phone, which I can't find right now. Oh, I pick up my cell phone and I look up right here, right? And so we've got the old system, the new system. How can we start to move in that direction? Knowing that we still have to honor what is set up and make sure that we are protecting those property rights. So that's what I asked for this group.
Thank you.
Yeah, okay.
All right. Moving it over to.
Who would like a break? Break?
We can do 300 first.
Folks online, okay, how about we do 300 and then we get into the one that is the long one.
The fun one.
We'll do a break before we go into that one. Does that work for folks? Okay. So let's see. So this one includes some updates to our definitions. Speaking of a system that's antiquated, I will try not to go on a rant about our definitions because we've still got more work to do on definitions. We are not solving all of the problems today. And so what you'll see here is we do have, in part because of this rulemaking, we've noticed that we've got definitions of protest everywhere, even rules that the definitions in 300 apply to. So we're going to streamline that and put it in one location, which is Division 2. Everything else will move towards pointing towards Division 2 on that front. So we have one definition, not 20. Often they say the same thing, we hope. Sometimes they don't. We also have an update to proposed certificate because it actually doesn't require a field investigation. So we're not quite sure why that's in there still, but that would remove that. We also have, gosh, I'm sure some of you are going to be shocked to hear this. Apparently, definition of a water right subject to transfer instead of the water use subject to transfer. That was a while ago that statute was updated with that definition. And yet our 300 rules still have the kind of old language. So we're opting to move that water right subject to transfer language, which by the way is in statute, into our definitions in 300 and stop having to repeat that in other definitions as well as having this conflict here. And then the other pieces, it adds, so our 300 or 380 rules, maybe 380 and 382, I think it is. They say that in addition to 300, these definitions apply in their rules. But 300 doesn't say that 300 applies to those. So this is really just making these all conform to each other. And, oh, sorry, it's 382 and 385. I had the wrong numbers there. So this is really kind of what we see as a cleanup. That's what we have before you today on the definitions. Kimberly.
Yeah, I guess I have a question just to your first point that your definitions do need some cleanup, and we would agree. Is there if you are not accepting comments or suggestion in this rulemaking, is there going to be a future rulemaking that is broader, that addresses definitions beyond the two bills?
You can certainly make suggestions. I don't know that we have plans for a future rulemaking right now. Sometimes, you know, before we can plan for a future rulemaking, we need to know what the problems are, right? And there's a number of rules that are in addition to, you know, this one that we need to do from this past session, like on our grant programs. I know you all are excited about that, but so there's more work for us to have, you know, to do here that is outside of these divisions. That said, when I was making note of not fixing all of the problems, some of it is, for example, I think it's Division 18, which is our conserved water program, right? Okay. I have a tendency to call that one a different number, so I got it right. And for us, it has its own set of definitions, and then 380 has some definitions, and 382 has some definitions. And I'm like, why is there so many definitions? So now, sorry, Kimberly, opened up the Pandora's box of my rant about our definitions. And so what we did was, where it was a very simple change that we knew had no repercussions, we went ahead and tried to fix the issue. So for example, the protest issue, it's very clear. There's other definitions where it's like, well, we really need to make sure that if we make it the same definition that's in 300, that we've thought through the implications of that. We don't have time for that now, so we didn't include that as an example. So you may see some definitions that appear that are kind of slightly similar. But unfortunately, you know, we're in that position of 17 rule divisions we're working to update, and we can only spend so much time on each one. And at some point we have to say, we just don't have time for this right now. So that was our calculus, because we wanted to get the rules out to you all, to have more time spent on them. So if there's a definition that you're like, this really needs to be changed, we'd love to hear that. At the same time, we are doing that balancing act of like, how much time do we want to spend on definitions this go around? So we're open to it. I can't say that we will tackle it, the whole world on that.
Okay, thank you. That's helpful.
Yeah. Other questions or comments on definitions? Leah?
Hi, Leah Kogan with GSI Water Solutions. These are very, very tiny minor comments, so I don't know if this is the kind of thing that you're looking for, but things like on number 16, drainage basin. So it mentions the US Geological Survey, and geological should also be capitalized. Is that the kind of like, I'm not trying to make any substantive changes, but just things like that?
Yeah, we'll take those, because those we can do without having to put through public comment, because those are just considered minor corrections, like grammar, spelling, those kinds of things.
I have a couple of those if you want those now.
Okay,
Yeah, so there was that one with geological survey, on number 19, fish screen. The last line, it says it's necessary to ensure its effective operation, and I believe that should be ensure. Ensure being more for like financial insurance versus making sure of something with an E.
okay, we'll take a look at that. I know sometimes our statutes use the IN versus the EN, and apparently what I learned this year, by the way, is that IN, sure, actually has a broader definition than probably any of us think about. So that one's a maybe, Leah.
Okay. Oh, that's great. I'm happy to learn new things. Number 32,
Okay,
planned. And maybe this one is also questionable, but I just wanted to ask, on the last line of that one, it talks about approved construction by both the public and private sector, and I'm wondering if that should be either or if it's requiring it to be like a public-private partnership type of arrangement.
I don't even know what that refers to without doing a deeper dive. So
Either.
Leah, can you, so that it was, okay, it was 32, and we need to look at
16, 19.
whether both is appropriate.
Or either.
Okay,
I think it should be either.
we'll get back to you on that.
Okay.
Thank you for those. Jeremy,
Yeah, just looking at subsection 38, the definition of protest references division 2, but at the top of this document it says this doesn't include division 2 in the applicable divisions up at the top.
that is correct. So division 2 would apply to 300. 300 doesn't apply to division 2. That makes sense.
Okay, appreciate that. Thanks.
Okay, thank you all for helping us clean up even the small things. Sometimes we find things and we're like, what does that mean? So, all right, certainly welcome to other thoughts on this. And Kimberly, like I said, if you do have ones that you're like, you know, wondering if we're willing to go down the rabbit hole, feel free to submit those over and we can take a look. Knowing that we're just gonna be doing that balancing act there. Any other comments on this one? You all are just so excited to get to division 2, me too. Okay, let's take a break. And we will, for those of you that showed up, Cassidy, poor Cassidy, does not know what she got herself into. She again voluntarily made baked goods. And for those of you that are coming to the room, they are delicious. So for those of you in the room, feel free to help yourself to snacks and coffee, use the restroom, and we'll be back in 5 to 8 minutes. So stand up, stretch, do all that, but do come back so we can start on what everybody I'm sure is looking forward to, which is talking about contested cases for the next couple hours here.
Okay, we're unmuted. Okay, hi, I got an email, I think from Jeff, and you wanted clarification on public comment. We do have a designated, I don't know if I see you up here. I'm looking. But for the group, we do have a public comment period at the end of the meeting. So if you want to comment on any of the rules, you can do so at the end of the meeting. Just want to make that clarification. But we will accept the public comment in writing as well.
Okay. We are back, we're recording and all of that. Great, okay. All right. We are now moving into Division 2. And so this one's a little bit more meaty here. And get my cover sheet up. As I was thinking through, the best way for me to summarize this is this is about protests and contested cases. Jesse, are you online? I want to make sure that I've got Will Davidson here as well as Jesse Ratcliffe, because my knowledge of contested cases is very minimal. So,
Jesse Ratcliffe was on earlier. He's not now. Do you want me to get in touch with him?
No, I'm on.
there he is. All right. So, I will be, yes. I will be occasionally, hunting things over to these two, for this section. But just to give you a little context, so, and Jesse and Will, if I say something that's incorrect, please correct me on the spot. I've got that permission, so we can make sure I'm getting accurate information out to all of you. So one thing for us to be noting here is Division 2 does not apply to adjudications. So set that aside for this discussion. Components of Division 2 do apply to all other contested cases the agency does. So want to make sure that's clear. If you look at the applicability section, that's where it says what rules apply to what. Okay. So that section is actually pretty dense in there, by the way, because we have another layer, which is that the legislation also has an applicability provision to when this applies for pending contested cases. So you'll see the applicability section is actually quite long. And in terms of the rules, so a little shorthand here for this is that in terms of the rules that are in this table, so if you look at your cover sheet, all of you pull up your cover sheet, this may or may not be helpful to you. So it was helpful to me, so I'm going to pass it on to you. So the applicability section, so 005 has components that apply to all contested cases and some to legislation. So just want to make sure that we're focused on that. Definitions apply to all contested cases. That's 0010. Then 0025 and 0030 and 0075, those are excluded from the 2025 legislation. So those are things that are not contested cases that were not included in the 2025 legislation. Another way of saying that is ones that are not in 690, 002, 005 sub 2, which is a very long way of saying that. So 35 and 105 And then 200 through 235 are all related to the legislation. And then 80 through 95, along with 175 and 190, are those rule divisions that apply to all contested cases. Brandon's like, Raquel, this is not helpful.
Can you say that last one again?
So 0080, so we have 80, 85, 90. That might be better than me trying to like block these things, right? So 80, 85, 90, 95, 175, and 190 apply to all contested cases, along with 5 and 10. So I'll do a recap of this again, because I realize now there's a better way to say this out loud. Sorry, Brandon's laughing over there.
It's all good.
Okay, so to walk through it one more time. 005 and 0010 apply to all contested cases. 25 is excluded from the 2025 legislation. 30 are ones that are excluded by the 2025 legislation. 35, the 2025 legislation applies. 75 is excluded from the 2025 legislation. 80, 85, 90, and 95 apply to all contested cases. So again, that's 80, 85, 90, and 95 apply to all contested cases. 105 is related to the 2025 legislation. 175 and 190 are applicable to all contested cases, assuming they allow exceptions, I should say that. And then everything else after that, so 200 through 235 are all the results of the 2025 legislation. So why is that helpful to know? You'll note that many of the changes are applicable as a result of the 2025 legislation. There are still, though, other changes that we can make that will make the contested case process either clearer or more efficient that can apply to all contested cases. As a result of the Administrative Procedures Act. So when we are adjusting or creating new sections that apply to all, that isn't necessarily driven by the legislation. So have I thoroughly confused everybody now?
When you're saying legislation, you mean House Bill 3544, because we have at least one in here that's House Bill 3342.
Yeah,
So
so
there's some
this
other
is
legislation.
3544 was about outlining processes as it pertains to protests and contested cases. There is a little sprinkling in here of electronic documentation from the other bill. So if this was not helpful to you, go read the applicability section and it will tell you all you need to know, right? So as we step through this, another way to track this is everything that is excluded from the 2025 legislation and doesn't apply to all contested cases. In the title, it says for protests not governed by 690-002-005 sub 2. So 005 sub 2 is the part of the applicability section where we are saying this is what applies is essentially arising out of the 2025 legislation. So that is a different way of saying almost the same thing. Okay. Let's see what questions and comments folks have. And we can, move from there through this rules division.
You mean on the applicability? Are we now moving through section by section?
Yeah, I'm opening it up to the group. So, James.
Hi, everyone. James Fraser from Trout Unlimited. I may have a couple questions in this division, but thought I would start towards the top in the applicability section 0005. There are a few places where that section uses the words "this 2025 Act," which struck me as odd because the administrative rules are not the act itself. So I would just recommend changing that to be more specific. It almost looks like a cut and paste issue.
Thank you for that. Let's, while we're on the applicability section, I think given how much content there is, it might be helpful if we move through methodically on this one. So does anybody else have anything on the applicability section?
Yes.
Okay, Kimberly.
A few things. One, I think as we stated last, I appreciate how you're trying to dissect things. But I think as I noted last time, some of this, I think the point here was to make a uniform process across the board. And this seems to us anyway, seems to be confusing things quite a bit. And in particular, I know some of the statutes weren't called out in the, in 3544 or the other one, but they also have no statutory authority right now or direction on protest. And in particular, it's the hydro stuff, like the conversion stuff. There's nothing in statute that says people can protest or file standing statements, but that was the state decided they had authority to do that in the Division 54. Long story short, it just seems like we should try and be consistent. I think it will be very confusing for everyone if we're not consistent across the board. So just noting that. So if there's a way, I'm not sure I understood I'll go back to our attorneys, but I'm not sure I understood the point about the APA. But if you're saying the APA allows you to make changes across the board, then I'm just trying to figure out why that doesn't apply here and allow you to make these changes across the board. Anyway, long story short, advocating for uniformity because I think this is just going to be super confusing. And then this is just a clarity point, which is on you have under 6A, when you're talking about protests that were pending, it says a person, so in A, it says a person that submitted a request for standing, actually, it's in a couple of places, that in an existing contested case proceeding, it's unclear if we're not seeing a sort of clear definition that you are now determining that upon the filing of a protest, it is in a contested case proceeding. And so some of these, there's a little bit of a sequencing issue. And so I think I'll submit some written comments, but I think the three of us who looked at this all thought it was worded a little awkwardly and could cause problems later. It's a small point.
Okay. So you're saying 6A, there's some.
Yeah,
issues.
6A, I think there's some other, let's see, it's in a couple spots.
It says an existing contested case proceeding.
Right, and so we just need either a definition of an existing contested case proceeding or some sort of clarity as to whether or not a contested case has been referred.
It's in B too.
Okay, yeah.
Okay. Yeah, so the way the legislation is written is that this applies to contested cases that have not been referred over to the Office of Administrative Hearings. right? And so if it's been referred over, then that proceeding is like off to the races. We don't want to change it. And so this is really about if there is a case that is pending and has not been referred over to OAH, then these provisions apply.
And I guess my
Does that make
point,
sense?
yes, that
Yeah.
makes
Okay.
sense, but I think my point is right now, just because a protest is filed does not necessarily mean there is a contested case pending, because the department does have the authority to not send it to, they have the discretion to not send it.
Oh,
It's
okay.
just a semantic.
I see what you're getting at.
Yeah.
Jesse, you get to be called on this because Jesse and I had a conversation about this during the legislative session. So let's see, it's quiz time, I guess, for me to see if I remember it correctly. Contested case proceeding, regardless of whether there is, whether there's even a protest, if the process itself is encompassed in that, because we had a whole thing over like whether it was, other than contested case and all that, but, so when there is a protest, which is a much easier concept to understand and doesn't make my head explode. But when there is a protest, even if it never goes to a contested case, that whole process is still considered to be a contested case proceeding. Jesse, is that?
So, so if the department issues a document that it is compliant with 183.415, and this is going to get very technical, that is a contested case notice. And the final order in that instance is an order in a contested case. And so for that purpose, that's the distinction between a order in a contested case that goes to the Court of Appeals versus an order in other than contested case that goes to the circuit court. The problem, and I think that what Kimberly's raising here, is that that is not the only way in which various state agencies, statutes, or rules sometimes refer to contested case processes. Sometimes it is a reference only to after you have a referral to the OAH, for example. And so I think that, my recollection is that 6A and B are copy and pasted from 3544 with, the appropriate references to 3544 itself added to it. But I understand the point here that we may need some additional clarification about what we mean in this particular context by an existing contested case proceeding. Hopefully that was helpful. This is one of these things where it's like, the terms can get used in different ways and it can make things confusing.
Okay, I've made note of that then. Thank you. Thanks, both of you. Yeah.
I just have one more question. I think you said this already, but this is not the way we were reading. I think it was 6A again, is that it would require an amendment of protest even after trial ends, and we're waiting for a proposed order or mid-trial.
No.
No. Okay.
This is about what hasn't been referred.
What hasn't been referred. Okay.
Yeah.
We might flag that just for clarity because there was some confusion.
Do you have a way to
Yeah.
can you suggest how to make it clear? Because I think this is from the statute. This is that applicability. So for those of you wondering, 6 is coming from House Bill 3544. Did I get the number right? Oh my gosh. One day I'll get it right. So so a lot of that's being pulled from there. And if we can make it clear for folks, let's do that. If that is helpful reference. And the idea is not intended, right? This is about being more efficient. If you're already through a contested case hearing, so you're already before an administrative law judge, changing the rules of the game is not efficient, right? So this is really about getting anything that occurs before that referral.
Maybe it can just say that. It has not been referred, if it has not been referred. Anyway, I'll just.
Okay. Yeah, for some reason, well, okay, yeah. I thought the statute had said something about it if it hadn't been referred, but maybe it.
I think that's addressed by sub 4.
Oh, okay.
Sub 4.
So that these rules wouldn't even apply. They would only apply if it hadn't been referred.
Okay,
Yeah,
okay.
thank you.
Thank you. Thanks.
So Kimberly, let me know if you still think there needs to be clarity, because
Okay,
yeah,
thank
it's
you.
subsection 4 is Will pointed out that is addressing, what does this actually apply to? All right, that was dense.
Sorry.
We're already getting into the nitty gritty here, and that's great. Anything else on applicability? And I'll say we can move into 10. So anything on 5 or 10? Oh, April, sorry.
So I guess just general comments, this whole section is very complicated. The bill was not one that I was directly involved, on the language negotiations. That was very much legal people from the respective interests, and I think, I'll be checking with folks and get you guys some feedback, but I think what would be helpful as we're going through this section, because I think we're all in similar boats on this one, is one, if you were someone who participated in those discussions, it would be helpful, as you did, Kimberly, to really share the feedback, because it will help, at least it will help me better understand why we have some of what we have in here. And then also, as we're going through, I think we got to it at the end of this discussion, but maybe instead of going into all the number mumbo jumbo and references, I mentioned this last time, if we could try and speak a little bit more common speak as we're going through. So like, as you were saying, Raquel, it's making sure we're not changing the rules midstream. And that aspect of like, for where something is being referred versus not, that I think will be really helpful as we're going forward to try and put it in those terms as much as we can. And I know we're gonna have to refer to the numbers as we go back and forth. And I also know that there may be some differences of opinion from people that were involved in the language negotiations, but it's also trying to be delicate and being blunt. It's a product of legislation that was shoved through without necessarily adequate time to really evaluate all these things. So I think in comparison to the efficiency one, I anticipate we may find some things that we will not be able to necessarily resolve as a RAC, and would suggest that perhaps as we go forward or encourage other people at the table, that if there are things in here that we can't resolve with the rule change, that we flag those maybe as a group and suggest to the legislators that were involved that they fix them, as they indicated they were open to doing. Because this one is, I'm not a lawyer and there's a lot of stuff in here. So just in the effort of trying to get things right, and then where we can't fix it, flagging that it's gonna need to be resolved elsewhere.
Certainly, and I suspect all of you will probably have your attorneys looking at this one and folks that are involved in contested cases. Oh, we've got more hands. Okay, Chris.
Yes, I'm just checking for clarification here. So in number 6, if I understand correctly, it really just boils down to, and again, please correct me, that if you sought standing and you're in a circumstance where the case has not been advanced by OWRD to the Office of Administrative Hearings by like 2026, like April 2026 or whatever, you have to go from standing to party status. And that's something that you have a little bit of time to do. And the other thing is that there are going to be standards for what your protest will require, which is a lot more rigorous declarations about what the problem is and why you're complaining and so forth. The details that will ultimately be carrying your argument. And so those things are a little more stringent. And so so you have to like update that, which is in section 3 of the House Bill 3544. So I guess those are the only two things I see changing that have to be addressed only with regard to what I would almost call inchoate contested cases that are sitting at OWRD but haven't really been sent to the Oregon Office of Administrative Hearings. And I'm just asking for clarity on that. Thanks so much.
Yeah, so essentially 6, and we'll see if I summarize, if my memory is correct. So I'll ask Will and Jesse to make sure that I'm staying on track with my recollection being that the legislation for folks that have requested party status, or in this case, it submitted a request for standing. If that case has not been referred, right? And they submitted it prior to January 1, because remember the legislation, the contested case legislation is effective January 1. So you'll need to meet the requirements of the statute, right? That you don't have to amend your request, but we will provide folks that information about essentially where this is landed, right? So we'll provide notice. And then it also requires us to provide notice to folks that protested. Folks that protested, the statute does require that they make sure their protest conforms to the new law. And so they will need to update it if it doesn't. Jesse, did I get that right?
So, yeah, I mean, so B addresses the kind of conforming the protest to the new standards. Sub A sets up a situation where someone had submitted a request for standing but has not yet requested party status and requiring them a deadline to do so.
Oh, okay. Leah.
I just had a question about one of the definitions. So if someone else has another question about the standing versus party status, I can wait.
Let's go to the definitions, and folks can, if we get another hand, we can go back to it while we're close enough. We can hop back one page.
Okay. It was on number 5. So it talks about like different ways that the documents could be provided to someone. But the last word is mailed. And so I was just wondering if that could be changed to like sent or delivered, or something that implies that you don't necessarily have to mail documents.
Leah, we will take a look at that one. I think I understand what you're saying, and I'm just looking at the way it's drafted. So we'll take a look and make sure that we've got that clear, that it's about applying it to the mail piece. I see they're kind of separated there, so.
Yeah.
Right. Seen any other comments? So let's move to 20, 25, and 30. So those are kind of the next sets of rules here.
Say 20, 25, and 30.
Yeah.
What about 23?
Oh, sorry, 2023, 25.
Okay.
So no, I'm including ones that we haven't had references to in 30. Obviously, our focus is on 25 and 30 here. So it's a reminder, these ones are for ones that are not the legislation. Go ahead, Kimberly.
So we had comments, so on a couple of these sections, so on 23, and we can give you more detail in writing, but I'm not sure that the language there captures the statute, which there's more limitations on how the state can participate than is clear in this section. So I can get you the specific concerns in writing, but just wanted to flag that. So that would be in the opening paragraph. And then
Okay.
actually did you say you're going through 30?
We're on 25
Okay.
right now. If anybody online has anything on 25.
25 and 30 here.
I don't know where this goes, but I do think somewhere in the rules, I'm not sure if it's here or elsewhere, it would be great to have sort of clarity about how the department is going to ensure that people have gotten, like, now that we can do things electronically, that there's some sort of, and maybe this isn't like outside guidance, but that there's like automatic receipt to the person who submits so that we know it actually made it in. So just nits like that, as far as like the payment and also submission of the protest, now that we can do this all electronically. And I guess also I guess we'd ask for some thought. I'm not sure if this needs to go to a rule or not, whether, it can be taken from accounts that people have with the department or whatnot, just sort of how payment can be received.
Kimberly, would you
And then-
elaborate on that?
Pardon?
Again, I don't think I understood the last comment about payment from accounts.
So WRD with some people, like Water Watch has an account where we just have, our accountant puts money in there and then we subtract from that when we're having to pay for things. And so just clarity on like what electronic payment means. I know this is a nit, sorry, I should probably maybe bring this up outside of this meeting,
No,
but-
this is a good point. So, and Katie, chime in if I'm wrong on this. So this is one of those areas where the agency would love to modernize. With the very limited IT staff that we haven't been able to implement electronic payments. So folks have asked about that, right? So this legislative session, we didn't get authority to be able to pass on the fees associated with it, because from our standpoint, we can't afford to take those on, right? That's the program that had these shortfalls that were discussed this legislative session. So we got that authority, but we don't have the resources to actually set up. So it's kind of the chicken or the egg situation where, well, we're not gonna even spend time on that if we don't have the authority to pass it through, because it's gonna make our budget shortfall even more, right? So, so that is one way that electronic payments, right, can be taken, is credit card, right? And so that is something we've made a baby step towards, but we still got more work to do. Where it gets complicated is that, of course, we want to modernize and, send more things via electronic mail, right? But if your payment can't be sent via electronic mail, then we're in that situation where we still need to wait for the check to arrive, right? Or for someone to come in and pay. There are some instances where we have folks that use, that work with the agency a lot and they have accounts with us. I'll be honest, this gets very quickly out of my realm of expertise. Our budget folks deal with this, right? I don't know. But so we do have some accounts that folks have that they say debit from my account, right? If they prepay, and I think it's prepay, right? And then it's debit from their account. So the question that Kimberly is queuing up is, if folks are sending things electronically, is it sufficient to say, and debit from my account? And if we confirm that that is possible, is that considered, I think, received? Is that kind of where you're going with that? I quite honestly have not gotten into those details. And so I don't know what we do today on applications, like do we have any processes and water rights related to this where people have accounts that because they do a lot of transactions or things like that?
I have heard of that. I haven't been involved in the details. Will, would you speak to what happens when we receive a protest in terms of acknowledgement and how that interfaces with fees?
I will, I believe right now, to the extent that I can, because by the time I receive a protest, the payment has already been processed. So, and when the protest is received, it's stamped with the date stamp. And so, right now, when I receive the protest, I acknowledge receipt of the protest. I provide the protest to the person who submitted it with a copy that includes our date stamp so that they have a copy that shows when it was received by the agency. And at the point I receive it, the payment has been taken care of. So I'm not sure if that's something where everybody submits payment by check or if there's some people who pay with their accounts.
Okay, thank you.
And are you saying that you can't accept credit cards?
That's correct. We have credit cards set up. Well, construction has that set up. It's been set up for a long time. And other than that, like we don't have credit cards set up.
But you could. It's not, under this statute, because it allows.
If you're talking, we don't have the IT infrastructure to set it up. That's where it comes in, right? And I'm not gonna serve our staff to write down phone number, get a phone call, write down phone numbers and then be like, right? So there's, it's that mechanic there that we still need to get set up. And our IT project list, foreshadowing for all of you that work on the legislative front, our number one budget issue is IT.
Right.
So you'll hear that for the next decade, hopefully. But okay, many decades. April.
Okay, I'm gonna come back to this point in a minute while I let my head not explode, but going back to the thing in front of us related to protests, which just in wrapping my head around this as well as for the benefit of other people, we're implementing two different bills. The one bill related to contested cases is the one that's this Division 2, but then we've also got the process improvements bill, which provided the department with the authority to accept credit cards. So on this one of the questions I had that kind of gets, was stimulated by one of the questions Kimberly had, which I think the payment thing, I'll come back to that. But looking at, as we're moving forward to do electronic notices and submissions, is the department planning on having it set up where there's going to be an automatic email that gets sent out when somebody submits something? This being separate from the payment issue. That's something I don't know if it needs to be referenced in here, but I think that would be something that would be helpful to have when you're doing that you get some sort of automated confirmation that indicates something has been received. The other part would be, because I know some folks have read receipts set up and, you know, you can get that, but also you can decide not to have that embedded. So I don't think there's necessarily the way where you can require that if something's sent by email, that you get a, you know, kind of like there's no email equivalent of certified mail. And I think that's one of the challenges kind of going through here, on both ends of the spectrum here of how can we facilitate this electronic process, but not take out due process. And again, I leave it to the legal people to go into that further, but I do think having some sort of automated thing that gives people a confirmation that their thing has been, at least submitted would be helpful. Going back to the other part, I also, Kimberly, you seem equally incredulous that if I'm, again, because I feel like I need to have that restated. So even though the monumental things that we accomplished with the process improvement bills, including allowing the department to move into the modern age of accepting credit cards and passing on the transaction fee, there's a concern that there's not people, IT, different things to do that. That seems to be a different conversation as we're going through to the process improvement side, but I find that extremely ridiculous because it doesn't cost anything to accept electronic payments and we do it. So that's what I'm saying. If you guys lack the statutory authority to pass on the fee, you now have that. If it's setting it up, maybe that's a different conversation of looking at some different ways to set it up, because I think it is something that the end users are wanting. And so if someone is wanting to see their whatever transaction process more efficiently and is willing to pay the 3%, 4%, whatever it is, people will do that. And I don't think this seems like something that we should be able to resolve. And I don't think it fits in the Division 2 necessarily, but I'm really glad that unless that's not the case, that we're learning about that now and hopefully can address that as we're going forward.
So I will say, I know that this was something that I had mentioned when we started the budget conversations a year and a half ago, but then I kind of fell out of those meetings, so probably didn't come back as a point of conversation. And that, so I will put it on our list of things to follow up on in terms of the details as to why we don't have the staffing at the moment to do this setup. We're always prioritizing our list of IT projects. So I'll look into this one because it's the details. It's been a while since I've looked at it, but I'll just say that I knew when we were going into legislation that this was one piece of it, which was where the first step was getting the authority to pass through, because otherwise the shortfall would just be worse. Knowing that then, if we had that authority, then when we had the IT resources, we would be able to launch it. So we'll put it on our list of things to follow back up on. I'll note that it does relate to the rules and it also doesn't relate to the rules, because on the one hand, relates to the rules and that we can put electronic stuff in here, but that's going to continue to be a barrier, right? And so that's why I do want to acknowledge it, and that's how it does relate to the rules. And so we'll have to do some more working through that on the implementation side. I don't know the mechanics of like what that all, Lisa Snyder does though, so she looked into it before on getting that set up.
Just to make sure, because again, my brain is struggling with expressing myself in a non profane way. So why would somebody do something electronically if it's not actually gonna get started until the payment has been received? I mean, that's something that's gonna come through in a lot of these things, and I think it's something we need to address.
Yeah, and to add to what April was saying, which I agree with everything you're saying, is it could also lead to confusion and possibly some more than confusion, but maybe some lost opportunities, in that if people are reading in the rules that they can electronically file, they'll file on the day it's due, and when they go to pay and run into that roadblock, then if they're in Bend or wherever, they're not going to be able to drive over and drop off a check. So I feel like we're setting people up to miss deadlines if one, we don't you know, if the state doesn't work to allow electronic payment at the same time we do this electronic filing. It's sort of meaningless to have the filing if you can't also pay at the same time, because then you'd have to take the same steps anyway. That makes sense.
No,
I'll just
this-
note that James Fraser
Oh,
has had his
sorry.
hand up in the chat for a few minutes.
Great. No, this makes sense, and this is one of those, I think, areas where the rule writing and then the implementation conversations have not yet collided, and they're colliding today, which is great. So we'll do a little bit more follow-up on that front, because it was in the back of my head that, oh, this was a problem, and it hadn't quite made it to the prefrontal cortex to digest until today. So, okay, James, and then Marika.
I was gonna bring a comment about the next rule provision, but I don't want to distract if you had more to say about this one in 25. My
Marika,
question's
do you have
about,
to add on this? If not, we'll go back to James and then we'll come back to you.
Yeah, I just wanted to flag, I agree with April and Kimberly and just point towards 220, which is coming up, a rule we haven't reached yet, but I think that's really where this conversation about allowing electronic mail without the ability to submit electronic payment. I think we can, once we get to that section, we can spend some more time there and we can provide comments, but I agree that we're setting folks up for a lot of confusion and potentially some missed deadlines if we don't clarify how they can submit electronically and align that with also submission of the required payment.
Okay. James, let's go to you.
thank you. My comment is about Rule 30 and is in follow-up to my comment from last week where I pointed out that Division 53, Rule 40 has a protest provision that stated it is exempt from Division 2, Rule 30. So now I've actually seen the edits in Division 2, and I can see that you're changing this rule here as well, and maybe intending to delete cross references to other administrative rules. I still think there's an issue that needs to be cleaned up, and the long and short of it is that someone needs to look at Division 2, Rule 30, Division 52, Rule 110, and Division 53, Rule 40, and make sure that they all actually work together in the right way. Just some more specifics. Assuming the Division 52 and Division 53 protest specifics are the hydro protests, which I think they are, you still have a conflict because this edited rule says as provided in ORS chapters 543 and 543A, but the protest specifics in Division 52 and 53 aren't actually in the ORS, they're in the administrative rule. So it's still not really all fitting right together, and I think it just needs some wordsmithing between the three different divisions. Thanks.
Thank you, James. I am tracking what you're saying. Thanks for flagging that. By the way, these are all good flags. Like all the things, everything everyone's brought up today has been really helpful. So this is why we have RAC meetings. So thank you. Keep on. All right. Other comments here? Kimberly.
Yeah, I guess I'll just repeat what I said, I think earlier on, but it's specific to this section is to the extent it's not dictated by other statutes, we would again urge that there is consistency across programs as far as form and content. And so like you guys, for example, you added the 543A, but that is not, there's not a, at least for the conversions, there's not a provision in statute.
Right. We'll take a look at that.
Okay.
I know there are some things that are specific in the hydro statutes. And so we'll have further conversations, but I think what I'm hearing is where we can make it consistent that we should try to. So we'll take a look at that more closely.
And just to follow up, like for example, right now in the conversion statute, it does allow for standing, but you did, as we spoke about last time, you guys took that out because of the conforming of the amendment. So to the extent you're taking out standing statements.
No, we took that out because we don't have authority to charge a fee for that. There is only one statute that allows us to charge a fee now for standing statements and, it's related to hydro. It's under, is it like 170 or something? But the rest of that, we don't have authority to collect a fee for standing statements.
What about protests? Because they didn't have a protest. That particular statute also doesn't have a protest provision.
I'd have to go look at
Okay.
it. I just know there was one piece that we deleted related to the standing statements, and it was because we looked at it and were like, no, there's not authority to do that, so that should not be in that rule, but we'll take a closer look at it. Okay. I think we're ready to keep moving along then to comments on 35. Do we have anything on 35? If not, 75 is next in the queue here. So this one's repealed because of the legislation, now that I'm looking at 35 here. Okay, let's go to 75 too while we're. Okay, now we're back into, oh, go ahead, Kimberly.
Sorry, I guess I just want to flag that in our experience, as identified by the administrative law judge has caused confusion in contested case hearings. So we would urge you to think about cutting that.
So here's a question. Do folks think that this rule adds value? You don't have to answer that today, but that's something we've kind of debated. Jesse, chime in here if I'm misremembering, but we've kind of debated to what extent this rule adds value to the process or not. So
We're talking about 75.
Yeah, so since most application processes are going to be covered by the rules beginning with 200 that talk about and that were covered in 3544. This rule is practically speaking going to come up most frequently in enforcement cases. There are already provisions of the AG's model rules that address what can be raised in those proceedings. My own personal take on this is that the rule doesn't really add anything. And as Kimberly pointed out, and as identified by the administrative law judge is allowed by applicable law, it's vague enough that it can create additional confusion. So that's, I think the way that we've approached some of this is to try to fix issues where we can within the scope of what 3544 was intended to cover. And then that kind of being the primary issue. And then as we're identifying things that we think we can clean up in stuff that's not covered by 3544, we're trying to do that. But there's a potentially lengthy list of those things and not necessarily the resources to get at everything that's outside of 3544. So bottom line from my perspective, at least, is that I'd be interested, just like Raquel is, in hearing thoughts on the just overall need for this rule going forward, but also, more specific comments like the one that Kimberly made.
Jesse, do you need to state what you are attending on behalf of today? didn't occur to me that I know on the legislative front, we usually clarify.
Sure, yeah, that's fine. So I'm here as OWRD's attorney, not speaking on behalf of DOJ. When I said my opinion, in that case, it was literally just only my opinion on that, not DOJ's or even OWRD's, but it's just something that I've seen in enforcement contested cases in the past. So joining Raquel and being curious as to whether folks have thoughts about this one. Frankly, it was just not one that we had the time to dig into before getting this out to everyone.
You don't have to answer that today, but that's just queuing it up. I know some of you are gonna run back to your attorneys and that's great. So, but we are curious on that front, whether there's been much debate back and forth is too much is probably, if we spend 2 minutes on something, that might be actually a long time, but I'm kidding. Okay. Let's move then to, I'm not seeing any hands on that particular item, so you all can think on that one. All right, so we're moving into 80. This would apply to all contested cases. So you'll see in these rules, we've got a couple that apply to all contested cases that I think are either trying to make it clear what the process is or trying to do a bit more modernization from our standpoint, clarity on expectations and just good case management from our standpoint. So that's why some of these are in here, even though they are not in the legislation. This is one of those that is not in the legislation, as are the next couple here, with the exception of electronic documents, which is in the other legislation. So I'll pause here, see if folks want to talk about 80. Or 85. Just Laura,
Just inquiring minds want to know.
okay.
What would be evidence to the contrary of receiving something? How do you prove a negative? I just, when I was looking at 80 and it says that it's presumed to have been received subject to evidence to the contrary.
Jesse, Will, I told you this was gonna come up.
I was just curious.
Because I literally said, there was so much discussion during legislative session about how do you prove a negative. I don't even remember what legislation it was on. I was like, this is gonna come up, but okay, let's see.
Yeah.
So here we are. Jesse, you on the spot on this one.
Yeah, and this is coming out of due process case law. And so I promise you there are examples of where, people have been able to demonstrate this, but it would require me digging through parts of my memory that don't get used very often in terms of, background legal knowledge. So but bottom line is that's why it's there. It's a due process concept that folks are at least provided an opportunity to say that, well, yes, the mail comes through 99.9% of the time, but I can demonstrate that it didn't this time. So
I think when we had talked about this, there was I could be wrong, so feel free to be like, that was not this conversation. I thought there was something about, well, they presumably would submit an affidavit saying that it was not received, and that would probably, push us to say, okay, it wasn't, but that in short of that, it would be presumed. Was that the conversation we had? Does that make sense?
Yeah, so that's going to be one form of evidence, right? Like, so, someone can go ahead and say simply, I'm willing to testify under oath that this did not happen. And there's a penalty associated with falsely testifying under oath. And so that's considered to be evidence. But I think, again, it's more about the overall concept here rather than what someone might specifically have to do is just having that concept reflected here because it is a due process concept.
Does that make sense? I wanted to give you at least a concrete example because of
Yeah, thank you.
my
Yeah.
conversation. So, okay. Great, Greg and then April.
Yeah, hi, Greg Capillas here, representing Oregon Groundwater Association. Yeah, I guess I haven't really been commenting much on what's going on here because a lot of this is stuff that I don't get involved with much, contested case hearings, thankfully. But when I see something like this, section 2 here, subsection 2, where it says that, that it will be presumed that it's been received. And I think about the kind of record that I've had with the U.S. Postal Service, especially, and it seems like it's getting worse. I mean, occasionally stuff gets lost. It just doesn't show up. Or it shows up, like way late. I don't know what happens, at the post office, but, I'm not sure that I just have some concerns, I guess, about relying on their service to to be reliable. I mean, it's just we've all probably experienced that, and I don't know what the answer is, because I can see where there is a kind of a need in order to sort of streamline things and make things more efficient. It'd be great if you can make that assumption, but I don't know that that's really a fair assumption that just because it's been mailed to the U.S. Postal Service that it's been received.
Thank you. I think we'll do some more discussion on this particular one. I think, I think that I understand the points being made. Say that. So, April?
Just kind of following along in the provision or the discussion here. So I think, if I'm not, again, I'm not a lawyer, but, let's say hypothetically, there was this one time that the IRS did not receive tax return, filed by our association. And, we got it all straightened out, but I learned in that, wonderful experience that the IRS is the only entity that is not subject to what's called the mailbox rule, which is generally speaking, if you put something in the postal mail, regardless of how increasingly unreliable, they are, you are considered to have done your good faith effort, unless it's the IRS, by the way. They have the requirement that it does have to be certified mail if you want to prove it, or guess what? You can now file electronically, which is what we've done ever since then. Hypothetically, yes. So I do think that this is something that's going to come up as we're going through other provisions as far as when things are being sent in the mail, what is, the requirements around that. But if that's generally my understanding is this is the standard mailbox rule, which applies generally speaking. But my question would be just making sure that this goes both ways. If the department is saying that if you're sending us something, it's considered to have been sent, it needs to go both ways. So if you put it in the mail and you're using that form, then unless you can prove otherwise, it's considered to be received. But I do think that all of this is another reason why we need to be shifting to allowing more electronic, because the postal service is so unreliable.
So I'll give you all just a preview into my inkling on this one. So I know this one is, I think we took this from another state agency's rules. That's interesting. The little bit of heartburn I'm hearing from some folks is similar to what I experienced on, the back and forth on this one. So I think the initial intent is, and so I'm curious if folks have thoughts on this. Maybe it's a different way to write it. Maybe we scrap it. I'm not promising to scrap it quite yet. I want to make sure I do a little more due diligence, but I am curious. I think the idea was that if we send a document via regular mail, it's received, that suffices still as notice if we did not accidentally, if we accidentally did not send it certified or registered mail. So, Jesse, is that kind of like, did I describe that right? Where it was really, so I wonder if there's a different way to write it to not say it's presumed to be received, because that's the part that makes me concerned is it's more that, hey, if you did get it and you got it via regular mail, and yeah, the statute says certified mail. This was kind of my understanding as to where it was. And so because you did receive it, it doesn't mean it's a violation of the process. Does that make sense? That's kind of, did I articulate that right, Jesse? Of kind of like a way, what I think we're thinking was a efficiency measure.
Yeah, so this is a complicated area, and the sometimes there are statements in both the AG model rules and a couple of things that we've added here that are just more putting up people on notice of what is the law. And one thing that I would like to point out real quick is that the two most important notices that get sent out in any department process by the department are the notice of proposed action. So what we're calling the proposed final order, in most instances throughout these divisions, and the notice of the final action, the final agency decision, whether or not a contested case has occurred. Both of those are required by the APA still to be sent by registered or certified mail. And so this is talking about other things. Mostly what we're hoping to shift over to electronic forms of communication during the course of the contested case process. But there are some folks who still don't have electronic methods of communication, and this allows them to continue to request that they be provided documents by mail. So I think, by and large, the idea here is that we're going to be moving to electronic communication. But it is important to understand that those two kind of most critical pieces are, when they're sent by the department, they're still being sent in this kind of more verifiable form.
Okay, so I think we'll need to talk about this one more internally, because I want to make sure we're getting the benefit there, because that's a little different than I think what I was thinking we were doing here. Any other comments on this one? I just want to acknowledge I've heard the concerns here, and so we'll talk more about that, I think, offline and see if we still think it's something that's important to move forward. Okay. Let's go to 85. The Kimberly and then James.
So this is just I think it needs to be clarified either here or in the first section on applicability, but in the applicability section, it says that the department will give notice to people who've already filed protest standing statements, whatnot, under the old rules. But it doesn't say notice by mail, and this focuses on electronic filing. So I don't know if we need to add something here that says if it's filed prior to the amendment of these rules, you will initially serve the file by paper and then request an email or electronic filing. The point being is, like, there's all these protest standing statements, whatnot, documents out there that people filed on paper, maybe without an email address on it because of an email address wasn't required. And so we don't want to lose those people. Like, you have to notify them, I think, initially by mail to let them know that it's going to be electronic going forward. Does that make sense?
Yeah.
And I know in the first section, you just said you'll notify them, but you didn't say in writing, so it might just be, or by mail, I mean. We just don't want people to get lost in the shuffle, so.
Jesse, was this intended to be for the initial protest, or was this intended to be for some reason in my head, I compartmentalized it. Doesn't mean it was correct to compartmentalize it. Was this really about everything that happens once it goes to contested case? And because unlike the discussion we just had about protests and the fee, there isn't fee related issues, and the OAH actually has an electronic system for filings. So can you just touch on that? Does this really go all the way up to the protest process?
So the intent of this was to be the part of, you know, once you're before the OAH, and I definitely hear, Kimberly, your point. We were not intending to cover this, you know, updated protest and party status piece with this. So I think that it makes sense to clarify that, whether it's either in this rule or in the other one. But yes, this is generally about, you know, when you're filing something with the OAH, once the case is kicked off, before that.
Jesse, I think we probably need to clarify it regardless in this rule,
That's
that it's
fine.
not about the protest, it's about once it's been referred, I think.
Yeah,
Is that, do you?
that makes sense. Yeah, thank you.
All right, thank you for that. James.
My question is about Rule 85 and its preamble, which has the word subject to this division. We started our overview of Division 2 by walking through which rules in Division 2 apply to all contested cases and which apply to only some contested cases. So I can just imagine someone reading this rule and wondering whether or not their case is subject to Division 2. And so my question is just, does this mean electronic filing and service isn't the default method for some cases? And if so, why not?
So Raquel, I can take this one if you want. So really the only process in the department that goes through a contested case that's not subject to the division as a whole are adjudication contested cases. There is no current adjudication that is in the initial phases of a contested case process right now. Before the department does that, again, it is highly likely that there is going to need to be rulemaking to address the division that pertains to that type of contested case process. So it's a pretty unique carve out, but that's what it's intended to refer to. So everything else, every other contested case process is subject to this division in the broadest sense, that at least some of the rules within Division 2 will apply to the contested case.
James, does it make it clear if we delete subject to this division? Because it's unnecessary to say that, I think, because that's what the applicability section does. Does that help if we delete that?
Yes, it does. And Jesse's answer made sense. It just sort of, the way it's written creates this sort of mind-bending exercise where, say you're in Division 53 and you're filing a protest, and you say, well, I'm filing it under Division 53 because it has its own protest form requirements. Does that mean I need to also mail it in hard copy? So yeah, I think that would be helpful.
So while all of you were talking, we were chuckling and saying not it for doing the adjudications rulemaking. is not planned and not on the list, okay? So don't get worried about it, but yeah, pretty much everybody ducked and said, I don't want to be a part of that one. So that sounds quite the rulemaking. Okay, let's go to, I just have to provide a little bit of levity here considering we've got so much work on our plates here. So thank you all for staying engaged. Let's go to 90. If there's still comments on 85, we can certainly discuss those. This one's about being able to consolidate or split proceedings. And the best example I can give you, if we have the same protestant and the same, if all the parties are the same on a various applications that have been protested and they relate to each other, that we might want to consolidate them. So that is an example of where this might make sense. Okay, I see Chris, and then Kimberly's thinking as to whether she wants to comment here. Okay, Chris?
Yes, I just wanted to signal my strong support for this concept because there could probably be no better way to streamline the contested case process than by taking a number of similar complaints, such as those that are almost indistinguishable from each other regarding in-stream water rights, and combining them into one process, essentially. The only question that I would have is what if there are, either applicants or protestants that complain about being grouped together? Do they get some kind of hearing or a process where they can air their grievance, or do they actually have no agency in that? And if so, does that have to be referred to? Thanks so much.
So I'm gonna look to Jesse on that one. I will note there is a process in the APA already related to consolidation. This tries to make that, I think, a more efficient process from our standpoint, again, trying to, we've got a lot of contested cases we need to get through. Jesse, can you respond to Chris's question?
Yeah, so the and this actually is taken from a rule that DEQ has, and my understanding is that there are similar rules that other agencies have. So this is primarily about the step in the process where this occurs. So for streamlining purposes, giving the department the ability to make the consolidation or bifurcation decisions essentially, prior to referral, rather than having it being a part of the process once it gets to the OAH. And so the way this is written and the way that, other agencies that have this rule operate is that decision is done by the department. And it's not one that then is appealed or otherwise addressed in the contested case itself. It's a pre-referral component. I will note that there is one item that we've been made aware of that will be something that we may need to address in this rule, and that is there may be an instance in where, which the department doesn't really have a position. There might be, linked protests that are sent over, but the department has no position on consolidation. There might be a case that is sent over that there are multiple parties that have an interest in splitting the case for some reason. And for whatever reason, the department doesn't have a position on that. In that case, what would happen is that then those parties would go through the process of filing something with the administrative law judge and making their case about why things should either be consolidated or split out. That's not reflected in this rule currently, and that's probably something that will be reflected in the next draft.
There's a couple items that we've identified that we'll be working through. And when we get an updated draft, we'll go over them with you. That's one of them, for example, that we've realized in the past couple days here, so. Kimberly?
Yeah, I'm just, our comments build on what Chris said, which is we do think that there needs to be a process around this. Specifically, we think folks or parties should have a chance to object to consolidation or bifurcation and have that ruled on by the ALB or the agency. And then this was just a note passed along. I need to get a little more detail on, but it says we should also address who gets to be a party in these proceedings. Because we've been involved in cases that were bifurcated, and there was some not everyone got to speak on every issue and caused some confusion, I think, some sequencing issues. But I'll get more detail on that latter point.
So I'm curious from an efficiency standpoint, if the concept is that, because part of it is trying to save time by having to do a bunch of briefings, right?
Yeah.
And so if everybody agrees that it should be consolidated, you know, by a quick phone call of like, hey, we think this makes sense, we think it makes sense. And being able to move on, I'm probably totally simplifying this. This is how it works in my head, okay? So, we don't have to go through briefings and all of that stuff that might occur through, you know, the more formal hearings process. Jesse, is that how it works? Like, so I'm wondering if a step could be, a modification could be that, like, we can, you know, consolidate with the consultation of the parties or something like that. Does that make any sense to you on that front, Jesse, or how does that still save time, or is that how it works on the, once it's been referred, that it's a pretty quick process?
So I've seen all sorts of things happen on this over the years. The way that the model rule is written is that consolidation, the AG's model rules is that consolidation decisions are subject to the approval of the agency. And so, but the way that that rule is written, you know, kind of presumes that there's a decision by the administrative law judge that then is subject to the approval of the agency. And that is 137.003.0525, if I'm remembering correctly. So that's the default process. What that means is that, you know, then you're doing briefing on that. We are, and one of the things that we're going to be, you know, getting into here at some point that we're, you know, absolutely looking for lots of feedback on is fitting this all into 180 days. And so there are some aspects of this where there's an effort to kind of front load what's happening. You know, so the department, on the department's end, sending out more information earlier on, you know, prior to referral or at the time of referral, so that the parties are better informed about what's going to be happening, for example, that allows the agency, the parties, the OAH to move more quickly. This rule and for, you know, the instances in other agencies where they use this, it's one opportunity to try to take care of an item on checklist before it gets to the OAH, rather than having to have it be addressed in briefing at the OAH.
April.
Thank you. First, I want to say I really appreciate having Jesse on, and his explanation is very helpful. So looking at this area, 90, I maybe from a different perspective, but I had a similar question as Kimberly did, as far as whether the consolidation or bifurcation can be challenged, or, you know, how that kind of agreement works. And I think if the notion is that everybody's in agreement, then that's, I think, a much more streamlined approach than if the parties aren't in agreement. And again, I'm not a lawyer, and OWRC does not directly engage in protests, but a number of our members do. And I know that this is something that can go in either direction, as far as folks wanting it to be either split or not. But I think if the goal is to streamline where there is agreement by all parties, then maybe there's a different way to phrase that.
I don't know if that was our intent initially, but it's kind of what as I'm hearing the feedback, I'm like, well, is this a different way to get there? So we'll look at that. And I've got a note of just the ideas that we're drumming up here, and we'll chat about it more, and then we'll get back to it.
And then this is not
Yeah.
specific to a section, it's just a thought,
Yeah.
is when we're going through this, so at the beginning, we have the applicability and, making the split between in the different sections where, you know, before April 1st of next year, before January 1st of next year, there's gonna be the existing procedures that apply, and then the rest will be going forward. After April 1st, this is only gonna apply to the new things. And so my suggestion that I'm not phrasing as best is maybe it would be helpful to have a section at the end of the rules that tries to tie it a little bit together for the folks that are in that before category, with the thought that after the effective dates, it's not gonna be as applicable, but these rules are gonna live on, and I hopefully will not have to sit through another revision of these rules during my time. So kind of, you know, with that in mind of like, maybe just put it at the end where for people that are after, they don't need to worry about it, but for the people that are still in the queue, something that kind of ties it together a little bit more. And or it may be, and I know you guys are, or at least my understanding is different folks are in contact with people who may be affected by these rule changes, but there may be a need to have something on the website, once these rules are adopted, that gives guidance to folks for the different paths they may be in, if that makes sense.
I wonder if instead of, sorry, I'm not a fan of, we've got so many rules. So I'm wondering, do we accomplish the same thing if we put it on our website and have copies available of like, here's the rules that were in effect, you know, prior to January 1, if your case has been referred, here you go, here's your rules. And instead of adopting new rules that codify the old provisions, does that make sense?
I like that idea, but I'm thinking we're already doing that with what you guys have given us, and I know that there's some stuff that's still subject to ongoing discussions that, later in this document, and that's more of like, if we're already referring back and forth, maybe pulling out some of the existing references that are already being, kind of the circular things that are in the document, and having that at the end to make it easier for people going back and forth. But
I might not be tracking. I think I might be thinking of. Are you talking about the contested cases or the provisions that apply to all contested cases? And then going forward, and then the provisions that are like, this applies to a subset, and just having those. Make sure they're all in the same spot, so you don't have to say like, oh, where is this one? Or are you talking about cases that predate this one and having a whole copying and pasted all the rules that were in effect at the time and putting them at the very end and saying, okay,
no.
so I'm not tracking. Okay, now okay, that.
I think, you know, that just again, getting from the non-legal perspective of, if the goal here is to implement efficiencies, if there's more confusion on which things apply to people, that's gonna lead to the opposite outcome.
Okay.
But not copy and pasting and.
Got it.
You know,
Okay.
simpler.
We'll take a look at that. We, for the most part, do have it organized in a way. Not 100%, but for the most part, it's moving in that direction. So we'll take a closer look at that. The other thing that I'm thinking of that we need to take a closer look at is, based on what I've heard from this group, is the more we can make things consistent, the better. So I think we need to look at what's the extent of our authority under the APA, and just what extent can we make things the same, or, you know, so we'll take another look at that again, just to. to see.
And not to belabor the point, but maybe it would be helpful, I know we're not gonna have time to do all this, the schedule's very robust as it needs to be, but staff people are gonna need to be able to implement these rules, and I assume there's going to be some internal guidance around that, not saying that we need to see that, but it might be helpful to, at least for some of these aspects, to go through, well, how is that going to work? Procedurally.
Are you talking about just reporting back to our membership?
Yeah, I
Communicating and helping.
helping them navigate how this is gonna work.
And I'm gonna take it a step further and say, you're not just talking about Division 2.
Yeah.
But you're talking about this entire
All
scope of rulemaking, like we're gonna need.
Not
so-
all of them, but I think particularly with the things where, for the people that we work with.
A number of them.
Yeah, that if you're doing
Yeah.
these types of transactions or you're involved in XYZ type of proceedings, there's some changes and
Okay,
they're complicated.
thank you for that. Okay. So let's move into Division 9, or not Division 95. So, Rule Section 95. So this one's got quite a bit in it. I'll take it. Let's go to Kimberly.
So, how to start this? I guess I'll just harken back to, I think, some of the opening comments that April made about how this legislation made it through the session. And also that there will be some things that I think we don't agree on, and this is one for us. None of the language here was in the statute. And of concern to us is that during bill negotiations, we fought hard against similar language and got it out. And so that it's appearing in rule now, even though it's not in statute, is very troubling to us. We have concerns with 1, 2, 3, 4, 5, and 6. So basically every section. I don't know that it's really worth the time to go through all of our comments there. I think our bigger message is this is a much bigger subject, I think, than we can deal with in half a meeting or 3/4 of a meeting. And if we want to talk about it, it should be carved out. And, you know, the appropriate attorneys be brought in, you know, I mean, I know all the stakeholders are here, but not all their attorneys are here, but it's a big discussion. And we have concerns again with pretty much every section in here. So, and I'm happy to go through them, but I'm not sure it's worth the time.
Kimberly, I'm aware of the concerns, right? And so I do want to address one thing. During the legislative session, there was a number of things that were in the legislation, so as Kimberly noted. And there was a number of things that got removed from the legislation because of how much time they had and how much time they had to discuss. And also because the agency already had authority to do it. So I want to just note that just because something was in the legislation and then pulled out, in some cases, it was just because, well, the agency has the authority to do that, so they can deal with that in rules. So I want to be clear, as you know, we talked about with this rulemaking, there are changes, and this applies to all the divisions. There are changes that are required by the new legislation. There are process improvements that the agency has identified internally that we have, or externally, some of them are your all's comments, but that we didn't need statutory authority for. And so even though they are not in legislation, they are being introduced here. And part of that is again, going back to, we've heard it loud and clear that we need to reduce our processing times and we need to reduce our contested case backlogs. So I know we're not gonna agree on this one. And I am intrigued with some of the comments, because I do know this is a significant change for folks. About maybe having some additional conversations with some experts, pulling some of the experts together on this. Because I do know this is important to folks. I did hear a lot of the conversations during the legislative process. And so I know that this is an important area, particularly for some of the interested parties.
And can I just follow up with?
Yeah.
I guess we are also curious where these how these were generated. They seem to, give some interest in advantage and some a disadvantage. And so we were curious, who came up? How did you come up with
This
this
is the
language?
department's position.
Okay.
These are the ones that are from the department. I don't believe we consulted with any external parties on this. This is about us trying to, from our standpoint, the longer contested cases are sitting out there, that is also, there's that balancing act, right? We want to give folks due process. There's due process by having a very extensive process, but there's also due process by getting a timely decision. And so there's that balancing act of how much is enough to make sure you get due process with the amount of information, and how much is enough to make sure you get due process because we're making timely decisions, right? And having cases sit out there for, what year are we in? 2025. So let's go back to over 25 years. We don't think that is also not giving people due process. So how can we move through these? Really, the goal is to be able to move through these efficiently. If you all have other ideas about how to move through them efficiently, we would love to hear it. Efficiently and cost effectively are kind of some of the things that we're thinking about on that front. So hopefully it helps in terms of context. It's that, making sure that we're moving things efficiently and we're giving folks due process. How do we meet those two goals? That's the goal. So if you've got answers to that, we're trying to fix this process, right? Okay, that generated lots of hands. So I'm gonna go to Jeremy, because I haven't heard much from Jeremy. Then we'll go back in the room till April, then we'll go back to the screen to Chris. And I think Kimberly, you've got a new comment, so we will go back then to Kimberly at that point. We'll see if you all remember that. Jeremy, there you are.
Here I am. Thanks. Yeah, I just want to say that, I support the points of efficiency and due process, but do want to echo the concerns that Kimberly was highlighting with this specific rule section, and similarly had questions about how the sort of specific numbers within it were developed. And I think if there was opportunity for the department to share some of the background, that would be helpful. I just wanted to flag one question that came up, sort of the interplay between subsection 3 and 6, where, certain, if staff time is going to exceed 25 hours, then it is pushed into a public records request. And then subsection 6 states that public records requests can't cause a delay in the schedule. And I was just curious from the department standpoint, it seems like this 25-hour threshold might be where there's sort of more complex issues that are being raised. Is there any sort of range of time that it generally takes the department to move through some of those more complex record requests that you could provide, so we could just have a little bit of better understanding about the potential implications of going through the public records request process, and that being a sort of pinch point in meeting this 180-day deadline? Does that make sense?
I mean, those are all really good questions. And my brain has gone blank on the answers, so we'll see. Let's see if Will or Jesse have responses to that. I think some of this is, and I think that's why some of this is at what point can we move things over to staff that have expertise in dealing with records requests, right? And so I think some of it is that, some of it is this, we've got in the legislation 180 days to complete these contested cases. And we need to have there needs to be some practicality to that, right? I also want to acknowledge, we've had some cases where we're pulling multiple staff to go work 40 hours a week just on pulling information together. And I'm not as close to those, so that's probably why I'm like, I feel like I don't have a great examples for you, but maybe some of the folks in the room here from our staff do. So Will, do you have anything to add? And then if not, I'll see if Jesse does or Katie. This is where I'm phoning a friend here. Many friends.
I don't have anything to add other than, we have seen those requests. Sometimes, I think more often with court litigation than with contested cases, at least in my experience here, get where extra staff are assigned. But I'm aware of contested cases where, large numbers of files have been requested and it's taken weeks of staff member time to scan and compile those. But I don't have anything further to add than that, so I'll throw it to Jesse if he has anything.
Well, I can also add to that real quick, if that's okay. So I just also wanted to point out resource constraints, right? We have one person in our purchase program, one person, that's Will. Now we all support him, but if he's being pulled off for substantial discovery requests, what else isn't moving, right? Who else isn't being served? So if we have a situation where we have essentially an inequity in the amount of time that we're providing service to one customer, we're not providing it to other people. And that's something that we're looking at too, is how do we be efficient and how do we be a little more equitable? Will points out court cases. That's certainly one case where we've seen discovery take massive amounts of time. One case where we spent hundreds of thousands of dollars that frankly we didn't have dealing with a discovery case. And I've had to assign, 2 staff members, and that's not the entirety of the people assigned, but just even 2 of my own to work on discovery cases. We've had to hire temps to scan 400 something file folders. That's not just 400 documents, that's the full contents of 400 folders to respond to discovery. So we're seeing really substantial drags on staff time, on efficiencies. And we want to provide you and the other stakeholders good service. And so this is an attempt to try and do that.
Katie, you are just like creating volumes of things here. Before I see, yeah, Jeremy, let me see if Jesse has anything to add to that, or if we've summed it up, and then let's go back to you, and then we'll keep going through our.
Yeah, so I'd like to just talk a little bit about what happens when the department receives a lengthy document discovery request in practice. And that is that in most cases, that's going to draw significant objections from the department. And the first step, that either Will or I or another DOJ attorney might be, going through is to call up the attorney and we're just trying to informally work through this. What is it that you're trying to get at here? And why do you think, these document requests are going to get at it? We're probably going to give an overview of our basic knowledge without doing an extensive trawl of what we think the department has. And so we're going to try to spend some time working through that to narrow that informally. If that doesn't work, then we're probably going to end up in a situation where we're, refusing to provide the documents and the other party is providing a motion to compel. And then we're spending an extensive period of time, kind of having that fight before the administrative law judge. The administrative law judge rules on that, and then we move forward. The backdrop to that is that the public records process is always available to the parties. And the agency is fully aware of that. And so they, there are a couple of differences between the public records request process and the discovery process. One, of course, is, is the payment of fees to cover the discovery request, or to cover that part of the process as compared to the discovery process. And the other is that there are some exemptions in the public records law that do not apply in the discovery context. So in the discovery context, the primary exemption is you're going to be exempt from attorney-client privilege information. So this 25 hours of staff time was an attempt to kind of balance all of those factors and say, we know that the public records process is available. We're going to try to set a cap here that is balancing the cost to the agency versus the cost to the person participating in the process. And importantly, that if the department says, well, okay, this is going to exceed 25 hours, that those exemptions that would apply to the public records law will not apply. So in other words, you're going to get everything that you would be able to get ordinarily through the discovery process. That's not to say that there still may not be, objections from the department and motions to compel and the whole bit there, but it is a calculated attempt to try to reduce that from happening. I will say that in a fair number of cases, we're not going to be hitting that 25 hours of staff time because the documents that are being asked for are what we would consider to be stuff that we would be handing over anyway, frankly. They're one of the steps that we're trying to take here is a move towards the agency producing its file. And now I get there's, can be plenty of discussion about, well, what is within that file? What is without? Are we missing things from that file? But the point is, if it's a part of the department's working process and an application process, that's being turned over at the outset. So folks just have that. And if what we're doing from that point forward is working around the edges of, well, maybe there's a handful of emails over here that weren't included in the file, I'd like those too. Great. That's not going to be pushing past 25 hours. The types of things that do tend to go past that are, a party saying, I'd like to see, every file that the agency's ever produced on this particular application type. And, just to be clear, we do get those requests. And so that is the point at which, we're quite obviously jumping past that 25-hour threshold. There's some nuance in between, but those are kind of some examples on either end of things. So so in any event, I will stop talking now. I know we got a lot to cover, but that's kind of an overview of some of the thought process that went into the document production issue in particular, and the balance of that versus the public records process.
So I will remind folks that there are levers, right? So you might think, okay, that's an interesting idea. I want it to be 10 hours. I'm kidding. I know some probably want it to go up, right? So just remember there's various levers here that you might want to suggest what you think is reasonable. This is a starting point. Jeremy, you had your hand up and I said I'd come right back to you. So
yeah, I can see the time to others. Jesse help answer the question, but yeah, still have some concerns here, but appreciate the explanation and discussion.
Okay, I think I lost track of who I had said. Did I say April and then Chris and then Kimberly and then Marika?
Yes.
I think Marika's new. Yeah.
Okay, so a couple thoughts. I will withhold final judgment on this section after talking to some legal folks. Again, I was not involved in the conversations during the bill, nor did I have legal folks who were specifically representing our interests. But again, Jesse's explanation was helpful. I think this can go both ways, and I get that the department is trying to reduce the burden, and at the same time, if you're already going to provide it, do some streamlining things, but, so we're in 95, 6. I think this has been answered, but it might need to be clarified that when we're talking about a public records request, not a basis for extending the hearing schedule, this is specific to Water Resources Department having a public records request. And I mentioned that since, districts are also subject to public records requests and other folks are, as well. I'm not saying that I think that's a good idea or not. It's just that if this is only specific to the department that,
Yes, this would be records filed under this provision with the department. And 6 is about, remember, we have that default hearing schedule also that fits everything in 180 days. And it's trying to push people, do all your work up, earlier in the process, don't wait right until the deadline. And then cause the schedule to get pushed beyond 180 days, right? So that's kind of what that is.
and I think because, and not knowing all the background of the conversation during the legislative process, and I made my statements earlier, I do have a little concern about putting something in that wasn't agreed to in the legislation, even if some of my interests may like what's here, or maybe we don't. I don't know. I'm being agnostic on it. But I think if the whole goal is to try and refine things so that you can meet what is in the legislation, which is that deadline, that you should just say that on the outset of it, or rephrase it in a different fashion, because I think that is clear. There is going to be a more truncated process and desire to limit time or the number of documents or page limits. I don't necessarily see that in here. I think it can sound good, but just trying to work within the statutory confines at the same time we're making streamlining. I had other thoughts, but I'm sure other people will have more.
Yeah. Okay, we're gonna go to Chris, and then we're gonna go to Kimberly, then we're gonna go to Marika.
Oh, great, thank you. My first thoughts on this section 95 is that these 6 subsections in here have the cumulative effect of making it seem like the ALJs cannot be trusted to do their job presiding over contested case hearings. To a degree, it feels like fitting the process into 6 months has the effect of alienating the ALJs. It's like, yeah, you guys, you can't really do a lot of your job because we need to speed this up, and we're just going to streamline this at the expense of taking away your agency. I want to be upfront about acknowledging the intent here, which appears to prejudice protestants who are going to be the folks seeking more discovery than the applicants and the OWRD. I mean, that's the whole point, right? Is to prevent the protestants from bogging down contested cases with a lot of spurious discovery. But won't they be the ones who are experiencing the limitations the most? I also understand that this is the intent and that OWRD has the full authority to write rules as it sees fit. So yeah, I mean, you can write all the rules that you want outside of the statute. That's the job of agencies. So, I would never question that. But I would question some of the, the ways it's going about. Number 1, regarding the request for admission, I just had a question as to how this would speed up contested cases. I'm under the impression that the RFA streamline the hearing by sorting out a lot of what's going on in advance. And by reducing any pre-hearing discovery, won't that just bog down the case later? I don't know, but that's a question I had. And then number 2, an administrative law judge may not have or order more than 5 interrogatories. Doesn't this undermine the ALJ's judgment? And that if the ALJ thinks more interrogatories are necessary, wouldn't that be okay? And I wonder how OWRD would know better than the ALJ on this matter. 5 feels like it's an arbitrary number. It seems pretty low. And I wonder if maybe an average or a mean number of interrogatories over past contested cases could be used instead of just the number 5. Pick something in the middle. Again, it feels like it would prejudice protestants more so than the applicants and OWRD, who are the folks who really actually possess most of the facts and the evidence that would be discovered. Protestants are the ones who are saying, oh, this doesn't feel right. This is why I don't think it feels right. By the way, show me your cards. And now it's like, well, we only have to give you a couple cards. I'm on board with this question number 3 about requests for document production. Quite frankly, when I read this, I was like, whoa, you guys, I thought there was like a curtain, not an iron curtain, but like some kind of curtain between the side of public records law and the administrative law, where asking for public records and filing for discovery, you know, are really 2 very different things. And to then say a certain amount of discovery over maybe an arbitrary number like 25 hours, all of a sudden becomes a public records request, feels, you know, to this not lawyer, really odd. And I asked the question, is charging fees after 25 hours a reasonable way to limit and hedge against unreasonable discovery requests? Like spurious discovery requests are now going to be charged a public records fee. And I just want to wonder if there's another way to go about that. And then telling an administrative law judge they can't order a site visit, I'm just going to come right out. This sounds really petty. Why boss around an ALJ's judgment on whether a site visit is warranted or not? And that might bring up a lot of questions. And then lastly, I'm on board with the same question too, is that if OWRD were to limit public records requests and, or rather switch discovery into public records requests and then put a time limit on it, that seems really awkward too. And that's really all I have to say, and thank you very much.
Okay, Chris, we've noted your comments here. Let's go to Kimberly.
Yeah, I think Chris raised a lot of the specific comments we would have raised as well. I will get you specific comments in writing unless you want me to go through some of these verbally, but I did just want to say, I think some of these, and Chris mentioned this as well, I think some of the suggested language actually goes against the intent of being more efficient. For instance, number 1, about the requests for admissions are not available. Of course, you know, our attorneys, their point on that was that they can be useful in narrowing the issues in dispute and making resolution more efficient, which we thought was the whole goal here. And so we have, you know, I think these need a relook, but I just wanted to take us back because you posed the question, I think, and then we had more comments, which is ultimately, we really do feel that there should be, we should pull this out and have a more in-depth discussion about this. You know, there's been requests for a work group on this in the 2023 session and the 2025 session. And I think this is really important. And I think we could figure it out if, you know, all the attorneys from all sides who are doing this work, like sat down together and came up with an equitable path here. And then I would also note, I understand the department's position is to try, you know, be more efficient. And we have this timeline set forward in statute, but the statute also allows for extensions for a variety of reasons. And, you know, as we all know, I think as everyone knows, contested cases are very different. Some are simple and this wouldn't cause a problem, but others are very complex. And I think the limitations would make things inequitable for everyone at the table. So anyway, basically just wanted to call out again that I think we need further discussions.
Okay. Let's go to Marika. And then Jesse, I'm gonna come back to you to see if there's anything that you wanted to respond to. It looks like we've got some things to talk about and follow up offline on, but,
Can we pause just for 1 second? So I asked Mindy to drop in the chat to see if anybody wants to make public comment. And we haven't received anything, so we'll probably just keep going, but I wanted to make sure if there was somebody that wanted to provide a public comment, if they have the opportunity, so.
okay, if someone wants to provide public comment, put in the chat so Mindy knows it. Mindy, please let me know. We will wait until the committee's done before we get to that comment here. So let's go to Marika.
Yes, thank you. And thanks especially to Jesse for the explanation and background. I agree with Kimberly that this section merits a more robust discussion. I think the department probably anticipated this, but seeing these proposed rules, adding some things we didn't expect that go beyond the legislation that was just passed, I think was a little bit of a sticker shock, and acknowledge that the department has, authority under the APA, broadly speaking, but just for the purpose of finding the incredibly important balance between due process in the efficiency sense and due process in ensuring that parties have adequate time and resources to do the necessary fact finding. I think my broad comment would just be, I think we'd appreciate more discussion, and we'd be happy. We will submit additional comments. And I think I'll just add one specific point here because I know we have a lot to get through. And so for the interrogatories, 5 seems low. That's obviously lower than the model rules. It'd be helpful to know how that number was identified. And then I think when we're talking about things where the department would provide written consent, it would be helpful to have some sort of like standard or criteria that the department is going to apply when it decides whether or not to consent to something like that, if in fact this language stays in, and presumably the metric would be, efficiency driven, but it'd be really helpful to better understand how the department might make that call if we go forward with these. So I'll wrap up my comments there, but I think this is a really important section, and I hope we have more time to discuss it moving forward.
Jesse, is there anything urgent you feel like we need to note for folks, or can we move on here?
Yeah, no, I'll just real quick. I mean, I just want to say thanks to everyone for, for getting these concerns out there. Lawyer too. Yeah, I write discovery as well. I get, the concerns that are being expressed here, and the goal is to try to find a balance between the amount of time and money that is being spent during the discovery phase of the process, while still acknowledging that, the parties need information to be able to, prosecute their cases. And again, in this particular intersection between the public records law and document productions, how do we handle that? Just for folks thinking, if there is additional discussion on this, that the one point I'd like to just make on the request for admission, and this is, I've done a lot of contested cases. I was the primary attorney on the Klamath adjudication, and that obviously had a lot of contested cases. I don't know if I've ever actually seen a request for admission that moves things along. They take time to draft, they take time to respond to, usually they're objected to. If there are issues in common that, that really are beyond dispute, they get stipulated to. And so, again, I think we're open to discussion on all those things, and someone can try to correct perhaps what they see as my biased view on this one, but just in reaction to kind of the points about, well, doesn't removing this actually, create additional time? That has not been my experience. Those tend to be a drag on the process.
Okay. We're going to move along here. It's duly noted that this one requires more conversation. So, and yes, I anticipated that, so I appreciate you all, with your comments, and, we will get back to you all on, how we're gonna, proceed on next steps there with this group. So with that, I wanna go to, walk us through briefly. Let's see, we've got 105 here, which is being deleted because it was, repealed by the statute, so I'm just gonna note that. We've got, 175 here, which I think is more just corrections, but I'll see if folks have comments on that one, or 190, which I think are kind of just clarifications here. And then we get to 200, which is new. So 105, 175, 190, and 200. Does anybody have any questions or comments online? James?
Just a very minor comment that administrative law judge shouldn't be capitalized in the new 175. It's not a defined term. It's not capitalized anywhere else.
I think we're using it as a proper noun, but I will check on that. I don't think we have been capitalizing definitions in this rule division, but we will check on that.
Yeah, that administrative law judge is used throughout the division. It's lowercase everywhere else. So.
Okay, thank you for that. Okay. So, we're at 11:45 here. And see the yellow highlights. Everybody is really having a fun time here, because I just lost my place. There we go. Okay. What's that? Is this something called fun? This is, hey, all the folks in the room think this is fun. I know.
Especially April.
I know that. Everyone's having a blast. Okay. The default hearing schedule, I'm going to ask that we.
Stop.
Pick it up for the next meeting.
I'm gonna say we skip that one for a second here, so, my people in the room that are taking notes, please note that we skipped that one. There's some, discussions we're having with OAH, that are good conversations that will help us make it better. So I'll ask, if you all have things you've observed, please send that over to us. I'm noting that we're running out of time here today. And so we'll come back to that one. I will follow up on the win. Because I know that's a question.
April has her card up too.
Okay, April, I'll get right to you in a second here.
Oh, no, I want you to finish. Go ahead.
Okay. I will note then for folks that we've got 210 and 215 that, I believe are basically from the statute. And then we've got, we've got ones that get quite a bit more detailed. So there's probably not all of these that we can get through today. So I'll stop there. I'm gonna open it and just ask folks if there are items you'd like to get on our radar today for the remainder of the rules, and we will sort through how we get back to, when we get back to these on another day. So I saw April, Greg,
I don't know what the best way is, but I think the section on discovery warrants more conversation. It may make sense to have that at the tail end of the rule process, since that's not something from statute, but it feels like there may need to be a parking lot, a bucket, whatever you want to call it, of things that we'll get back to. And that would be one, at least so far. The other thing is, so I see that, so I guess just a little bit of clarification, the section here that starts that this is gonna have more conversations with the Office of Administrative Hearings, does that apply to just that going up to 210 or 210 beyond? I asked specifically both so that I have a good understanding of that, but also in asking legal folks to review, it's problematic when I tell them that the language is going to change, because then they'll just say, well, I'll wait to review that, and then they won't have time to review it, and that'll make me mad. So that would be a question, but then the other part would be, going forward, if there's pieces that are going to be subject to additional discussions with people that are not at this table, can we just not talk about them until you've had those discussions, in the interest of us focusing on the bulk of what we have? And then the last part would be, could you give us an overview before we conclude today of what we're gonna tackle at the next meeting and the approach to that?
Yeah, so, this is a lot of rule divisions. I know you're all feeling it. We're also feeling it. And so on the question of, can we not talk about things that we know we're gonna have conversations with other folks? The unfortunate answer to that is no, in part because I don't know, right? So we have had a small team that's been drafting these rules and that have been trying to move them forward. And then while we are coming out to you all, as a reminder, this is the part of the process where we can ask anybody and everybody for their thoughts on the rules before we go out to public comment. So we are, we've reached out to, well, we've sent it out to you all because we want to get it to you as soon as possible. We've then turned around and told our staff that are not part of the core drafting team, if you catch something or if there's something we haven't addressed, that they can comment on that to us, as well as other state agencies. So some of this is unfortunately happening simultaneously. I can note to you that we've started some conversations with OAH, who, by the way, I'm very impressed with their workload. Feel free to ask them about that. They are moving through hundreds, thousands of contested cases. It's a lot on some other issues that they've got before them, but so I appreciate that they gave us some feedback. So we're going to take a look at that. And I know for certain this is one of those. There's a couple other ones that are minor, I think, changes that we've identified. We can certainly get those out to the group earlier than later. They are probably not as substantive as this schedule for hearing. So if you want to hold off on the schedule for hearing, that would be the one I'd hold off on. I think the rest of them are pretty close, from the internal view on that front.
And to answer the question, I think you were asking if the yellow highlight, I think it just pertains to this particular rule, right?
Yeah.
Just to 205.
Yeah.
Yeah, just to 205. We took a shot at a schedule and then we had not had an opportunity yet to check in, and OAH provided us with some good thoughts on it on Friday that we reviewed. What is today? Are we at Tuesday or Wednesday?
Wednesday.
We reviewed it yesterday, so we still haven't fully gotten through that, but so that one I can affirm we'll make some edits to it because they did give us some really good comments about that. We will get to next meeting.
No,
That's on Laura's plate. We're not doing that quite yet. April, did I answer everything?
Yeah, I think that based on the response, we're gonna need to revisit all of Division 2 at the end where you have that scheduled, because there are components here that interrelate, and at least it seems like that's gonna be most helpful in understanding how protests will be going forward.
So we will make sure to make it clear. So if there are changes made as a result of this group or the staff interagency conversations, we are going to be highlighting that so that you can clearly see it in any follow-up documents.
Yeah, and just to emphasize for
yeah.
folks that may be like, well, why is she belaboring it, is because for all of us who have to ask our legal folks for feedback, that's not a quick turnaround, and I want to make sure we're giving them both thoughtful feedback as well as being responsive to representing our member interests.
Yeah, okay. Thank you for putting a finer point on that for us. Greg, thank you for being patient as I've been rambling on.
Yeah, hi, thanks. This is Greg Capillas representing Oregon Groundwater Association. I wonder if it's appropriate for me to make some comments on the mapping standards that I was kind of, I was trying to think about how to formulate my comments, and then we kind of moved on, but I kind of feel like someone, coming from somebody who has done a lot of mapping, I thought, I would like, it might be important for me to, at least weigh in on some of the discussions we're having. So is that okay if I make some comments on the mapping right now?
Let me go to Chris and see if if he has comments related to the division we all have pulled up. And then that is a cue for the crew that is working on 305 to get their pens ready. And then we can come back to you.
Sure.
And then I see Kimberly has a hand after. So we'll go to Chris, then we'll go to Greg. Kimberly, is yours on Division 2?
It's on 205, yeah, just really quick, or I can just,
Okay.
what's up there?
Okay, so sorry, we will go to Chris, then we'll go to Kimberly, then we'll go to Greg. And we are basically at time. So that's the close of the hands, okay? If you have other thoughts, email them to us. Laura will make sure that we can collate thoughts that we have received via email, and we will make sure we send it out to the group. So that way, everybody's getting the same information here. So with that, Chris?
Yes, very briefly. So this is commentary regarding this close of the meeting discussion about, what to do. And I want to echo the importance of anything that we send to you in email related to this RAC process, any communications that happen outside of the time when these meetings are recorded. I would request that OWRD memorialize them in the spirit of the governor's letter from back in February. She wrote in her letter, each agency shall publish public comments on their website during the rulemaking process. And one of those bullet points says comments made in writing during rulemaking advisory committee meetings. And I want to point out that that seems a little odd because most comments during rulemaking committee meetings are oral, they're not in writing. So I would interpret that as any comments that are sent during the rulemaking process related to conversations that were had at committee meetings. So for instance, I'm going to be sending more detailed information regarding Division 305 and Division 2, and I'll be sending that to OWRD staff. And I would request that OWRD staff find a way to have a link or a Dropbox location or some kind of place on the OWRD rulemaking web page for this process, where anybody, just myself, can just go in, click on a button, and just see all the submissions that have happened in between meetings. I know that might be a little bit of extra work, but I think that we would all benefit from being on the same page as side discussions are inevitably going to happen. Thank you so much.
Chris, on that point, we do, because the deadline for the first set of comments, from our prior RAC meeting, that's October 1st. So I'm going to wait until October 1st. I'm going to pull everything together that we've received. compile those comments, the emails and anything otherwise in writing, and we'll post them and we'll go rack to rack, based on the deadlines we set for receiving input. And if we get anything that falls outside those deadlines, we'll post those as well. So we do plan to put them up on the website, just haven't gotten there yet.
Well, great. Thank you very much.
So I will note that that's, related to the, that does not include the staff comments or the interagency comments. We will be working through those and then we'll present you all with the unified position of the agency on that front. But you will get updates on as to what those are, should they move forward. Okay, Greg, and then, Kimberly, and then Greg. So you had something on 205?
Yeah, just really quick. I know you don't want detailed comments, but I just wanted to be forthright with folks that what we would urge is moving away from any sort of cookie cutter approach. I mean, every case is different. We think that deadlines should be set in each case by conferral and pre-hearing conference. Because again, some are simple, some are complex.
So we are required by the statute to develop a default hearing schedule. So, and I think that this is a starting point, right, to get there. If you think there are different approaches, so for example, an in-stream water right case should follow this kind of timeline versus a extension case. I think we can have multiple default schedules. Another idea we had previously talked about was, simple case, complicated case, in some example there. But part of the idea behind the default schedule is to be able to give folks notice up front. Hey, this is what the schedule typically looks like. You should be ready, right? So this is about moving things forward and also giving people clarity on what to expect so they can be prepared. And also to reduce the amount of time having to negotiate over scheduling. And also, as a reminder, the statute requires, I know there are exceptions, but if we only do the exception, which is to exceed 180 days, we are not meeting the legislative intent right there, which is that most of them should be done in 180 days and the exception should be outside of the 180 days. So certainly open to additional ideas if folks have that. This is our first shot on it, knowing the sideboards. And if it is helpful to note, someone asked us this question, Jesse, let's see if I remember the answer, which is, it is the 180 days is from referral to OAH to, it's not, is it closing what is it, closing arguments or,
Yeah, I can't actually remember. I think it's supposed to be that I don't know if what we wrote down here, hearing complete, is literally what's in the statute. That may have just been a shorthand. But I think the idea is that the actual, showing up before the ALJ,
yes,
part of the process is supposed to be done within 180 days. That doesn't include closing briefing.
thank you. That's looking for.
So yeah, that's the target there.
So it doesn't include the ALJ issuing their proposed order. So that's it. That was in the statute. And so just someone had asked about that. That probably will help you with your comments. Okay, Greg, you wanted to go back to 305. If you have really detailed comments, I'd ask you to submit them in writing, but we've got our crew here. They're all sitting here. So if you've got some comments, that will be our, do we have anybody that wanted to do public comment? Okay, so we will go to Greg and then we will go to Laura, who will do a quick next steps recap, and then you all will go. So let's keep it, we are over time now. So let's keep it moving here. Greg.
Yes, thank you very much for giving me a little bit of time and for letting me to go backwards a little bit here. As a water rights examiner, my company has done probably literally hundreds of maps over the last 25 years. admittedly, we're kind of old school, but, our system works well with the with the public land survey system. And there've been some good arguments made, I think, for, the reasons why we're using that system. Christopher made some really good comments about, using geospatial data. That's probably where we're headed eventually. But, based on our experience, I think we have reason to believe, I think that the geospatial data are certainly precise, but we have reason to believe that they're not always necessarily accurate. And at least not at this point. And so I would be hesitant to rely only on geospatial data for preparing these maps. And I will be probably submitting some more detailed written comments. That's all I really had to say at this point. Thank you.
Greg, thank you for those comments. And I would ask that, just to reiterate earlier, is there a way where we can continue to make sure we have what we need from our past and also start to move in a direction of the future? And that does mean maybe it's an and that we require two things. So I'd ask folks to think about that, whether it's requiring both of those things instead of just one or the other. So eventually we can move into the new era. But all right, so we are at time. Laura?
Yeah, so up here on the slide, I just have the divisions we currently have on the schedule for next two RAC meetings. It sounds like the rest of Division 2, we're not gonna carry that over. We're gonna put that at the end, or are we gonna think about that?
I'm gonna think about it.
Okay,
Sorry.
so
folks.
this may change, but currently for the 14th and the 15th, and those are both hybrid, 8:30 to noon again. We're covering 3:10, 18, and 3:15. And then Division 17 is the one we moved up. That's the cancellation forfeiture one, move that up. What you heard today, to the extent you are able to provide written feedback, please try and get that to us October 8th. So that's 2 weeks from today. And again, another reminder, October 1st, so that's next week, if you can give us input on what we covered last week, as well as respond to that poll. I'll check the accuracy of my poll, and I'll resend out just a reminder just with the polling. So you all remember and can find that link easily. And
What's the due date for the poll? Is it?
I set it for October 1st. If you can get it sooner, because we're on Wednesday already. So if you can get it to us sooner, great. I think I checked this morning, I think only a couple of people have responded. So that's why I want to give folks a little more time. So October 1st for the polling for November availability and for input on what we covered last week in our RAC meeting. And then October 8th for what we covered today. And then the schedule for the 14th and the 15th is up there.
So I know you all are all A+ overachievers. So for those of you that want to get us comments on rule divisions we've yet to cover, feel free to do that. I am sure we'll have a lot of takers, but these are not limits on your ability to get us stuff before, because obviously there's a lot to cover here, so. All right, thank you all. There's a couple more cookies left. For those of you online, imagine delicious cookies. So they were very good.
Just leave these here.